Lord's pleasure and permission, we have put in the serial number 3 under the heading for admission.
Don't mention.
Only today I have received the no objection.
Please don't mention those cases which are all already on the list.
I was seeking because
you are seeking time, no, but let the case be covered.
I'm sorry, Lordship. Lordship, I've heard this matter on 7th, Lordship, and reserved the order, Lordship. Lord, the executing court, Lordship, has issued a writ of dispossession, Lordship, will be.
You have to wait.
Because I will be dispossessed today, Lordship.
I don't know. The order is reserved and the judgment will come. They can't do anything.
It's an election matter relationship for hearing an election. In the law, I'm from the side of appellant in election.
You're outside this?
Yes, it's election.
Outside is sub division.
I came before on 12th of January. You told me to come on the date when the case is fixed. Today it is fixed on serial number 46. It is not being taken up from
Serial number?
48.
Under what heading?
Under heading hearing litigation.
Who are you?
And for the appellant.
Plaintiff or defendant?
In this case, the appellant and the original should have been defendant. An execution case has been filed for executing the decree, which is against me just because litigation.
Is it second appeal or first appeal?
First appeal.
First appeal.
Yes, just on the basis of unregistered development agreement, they have executed a decree. And
is it your case, Mr. Sam?
Petition.
Who has to argue the case?
Yes, my senior will argue.
Who is your senior?
Mr. Kalyan.
Who is the other side?
Other side, I think, Kundan Kumar Kumar sir.
If you have to mention, you have to get rid of the other side. You have taken consent.
No addition.
You have to take consent, isn't it? Call them. Call both of them. Call both of them. Right? Come back at 2:15 and call both of them, and then we will see.
Leadership from the list, leadership it's a hearing matter, we will inform the other side. Leadership it's a hearing matter.
We are seeking adjournment.
Leadership may be taken up today.
No, you see, we have a heavy board, we have writs also. It is now very, very, very difficult to take up this civil matters. I have to take care of all the matters, no?
Leadership it may be fixed for tomorrow.
I'm not so fast as you are.
Leadership from the list itself, which you counted listed today as white slip only. Item 35, order starts from 16 onwards, and the executive board is proceeding. Leadership, it's a matter, it should be an open and shut case because of land, Bihar Land Reforms Act itself. But then the executive board is giving all the time, they are giving very short dates. Next date is on 21st.
Second appeal or first?
Second appeal.
Admitted.
It will be a first listing. There is an IA first stay also because the
first listing means are you ready with the substantial question of law?
Yes.
Okay, we will hear you on the substantial question of law. We will not grant stay. In second appeal, unless the case is admitted on substantial question of law, I will not grant you any stay. You come prepared. When you want 250, you come. Serial number बताइए.
That is 35.
35. You come with substantial question. Other side is not required.
Next.
Serial 35.
From the daily list, fixed case, item 9, second appeal 102 of 2025.
Yes, please. Choose for the other side. You are there.
Just reading the plaint first.
First, read the substantial question.
Substantial question.
Order dated 12/8/2022.
Three substantial questions were ordered.
You read the entire order. One.
Whether the judgment passed by
So you read para 2. Para 2
paragraph 2 of the
of order dated 12/8/2022.
Learned counsel for the appellate has submitted that though they are concurrent finding regarding landlord tenant relationship by both the courts, but substantial question apply rather in this case. He has submitted that it was a specific case of plaintiff that the defendant was a tenant of Srimati Vyasudev, who is the vendor of the painting. And the landed trial court has travelled beyond pleading in Azerbaijan. The landed trial court has relied upon the judgment passed in Title number 125/89. Where it was recorded that the defendant has claimed that he was paying rent to Gurubak's court and the lower sea. The landed council has further submitted that the trial court has relied upon the compromise decree in which certain transactions of money were also recorded, but the same could not be relied upon as it was an unregistered account and hit by citizen registration. In view of the submission made by the landed council of the appellant, this could admitted whether the judgment passed by the landed courts is vitiated on account of the courts leveling beyond the pleading of the respective parties. Second, whether the judgment of Petition number 125 of 1989 could be used to rely the evidence of the defendant in absence of certified copy of the legal disposition, and whether the statement recorded in judgment can be treated as an admission. Third, is whether the landed courts have erred in relying upon the unregistered compromise decree passed in FA number 268/1995R and holding that there is no need of atonement of tenancy without properly considering that the deed of compromise was hit by sensibility of the registration act. These are the three.
The compromise decree amounted to transfer.
Yes. It is recorded in the compromise decree. There is various multi-transaction laws.
I agree with this.
As with the plaintiff in his pleading, I will read paragraph 1 of the pleading. That the lands of municipal survey plot number 1459, 1460, 1461, 1462 and 1463 corresponding to old municipal holding number 568 and 569 holding number 582 and thereafter holding number 389, 390 and 391 and present holding number 929, 930 and 931 within the ward number 3 of the Ranchi municipality.
You are reading
Paragraph 1
Paramana.
of the plate.
You read it from the judgment. Is there any error in the judgment? You read it from the judgment. In second appeal, it is not always necessary. You can read it from the judgment. This was filed under BBC Act.
BBC. Hold on.
You can read from para 2 of the trial court judgment.
Check. Invade the property along with other municipal number by Uparam Chaudhary through family partition in the year 1995. C. On account of natural law and affection executed the registered deed of gift dated 14/12/1935 in favor of Patapi Devi with respect to the above mentioned property, who accepted this sale and came in possession of the share. Said Patapi Devi also on account of natural love and affection executed to the registered deed of gift dated 30th April 1954 in favor of her daughter Vyaso Devi, who accepted the same and came in possession of the property and other properties. Said Vyaso Devi transferred the property in favor of the plaintiff to register deed of sale on 4/4/90. There was a title suit number 155 of 79 before the court of Judge Sarun, Ranchi, with respect to suit premises, and Vyaso Devi was one of the defendants. The suit was decided in favor of Vyaso Devi. The first appeal number 268 of 1995. The said appeal was disposed of in terms of the compromise dated 30th July 1998. Plaintiff is thus the absolute owner with respect to the premises, having acquired the said to register deed of sale dated 4/1990. Defendant is a month-to-month rent with respect to the premises in such on a rent of ₹60.
Just hold on. There was already a registered deed in favor of Vyaso Devi,
No.
right?
A resident of gift.
4/4/1990. So whatever it is,
In favor of plaintiff. That was in favor of plaintiff.
Vyaso Devi transferred the suit property in favor of the plaintiff through the registered deed of sale.
Sale.
There was already a registered
Deed
deed
of
of sale.
sale.
There was some dispute in connection with the property, and ultimately which ended in a compromise. And the plaintiff is claiming the property not by way of compromise, but by way of registered deed of sale,
I'm coming to
isn't it? As per the case of the plaintiff.
that. As per the case.
The plaintiff is not claiming through any compromise.
It is
The
also.
plaintiff is claiming through registered deed of sale. This registered deed of sale is covering the suit property or not?
Okay.
Yes. Continue please.
In the month of January, with respect to the premises such on the rate of ₹60 only per month, payable effective in this calendar month, on or before 7th of each subsequent month, since before purchase made by the complainant. After purchase of the premises, premises in suit, plaintiff immediately verbally requested the defendant regarding purchase and requested the defendant to atone him as his landlord and to start making payment of rent to him from April 1990 and onwards. The plaintiff's vendor, namely Srimati Vyaso Devi, also verbally informed the defendant immediately after sale and requested the defendant to atone the plaintiff as his landlord and to start making payment of rent to him from April 1990 and onwards. Despite the above facts, defendant has neither paid or validly tendered the rent of the premises in suit from April 1990 and up to date. As such, he has rendered himself liable under section 11 of the BBC as well as the plaintiff has purchased these premises for his own use and occupation as well as for the use and occupation of family members. The plaintiff is making a of doing business or jewelry in the premises of the occupation of the defendant, and he also wants to reside the premises along with the family members. The plaintiff is claiming arrear of rent from May 1996 to 1999 at the rate of ₹60 only per month.
Now you come to the next paragraph, defendants.
Defendant. In the always stated that they were such as a plot 61 and 63 belong to one Dattaram Punjabi, and there was a series of litigation between his descendants. Attitude number titled to the MS plot number 61 and 63 was being claimed by one Pratapi Devi, who had made deed of gift and cancelled the same. It is denied that the MS plot number 66 was corresponding to municipal number 66.
No, I don't get it. You read it.
I read that.
Selective mat karo. Defendants
It is
in
denied
others.
that MS plot number 57 is corresponding to municipal
You
plot number.
read slowly, please. Para number 4, you read it fully.
It is
What was the
denied.
case of the defendant?
It is denied that the MS plot.
Kaha it is denied that. But
That
the
is the
defendant in
point.
WS stated that
Municipal survey plot number 1461 and 1463 belong to one Datta Ram Punjabi, and there was series of litigation between his descendants. Title to the MS plot number 1461 and 1463 was being claimed by one Pratapi Devi, who had made deed of gift and cancelled the sale. It is denied that MS plot number 1469 to 1463 correspond to municipal holding number 568 and 569 or to holding number 389 to 391 or holding number 921 to 931. Alleged deed of gift in favor of Vyasudevi became non-est because of cancellation of the sale. Several deed of
the
gift
cancellation, this gift deed was cancelled. The gift deed was
was
cancelled.
cancelled but not
So,
opened
just a moment. This gift deed
in favor of Vyasudevi.
in favor of Gyasodevi was cancelled and it included the suit property. Okay.
Several deed of gift supposed to have been executed by Pratapi Devi have been cancelled. Defendant denies that Vyasa Devi has ever accepted any gift in favor of in her favor as alleged and ever came in possession of any portion of MS plot number 1461 or 1463 or any other plot subject matter of alleged deed of gift in favor of in her favor. Vyasa Devi did not sell any portion of MS plot number 1461 or 1463. The description of the property given in civil delivery is vague, incomplete, and incorrect. Also, there is no relationship or landlord and tenant between the plaintiff and the defendant. The plea that the defendant is liable to be evicted because of default in payment of rent is equally baseless The plaintiff should in fact and effect one of the declaration of title and recovery of possession to avoid inevitable dismissal of such suit because of limitation. The plaintiff has conflicted plea of the defendant, plea that the defendant is a tenant and he has landlord.
Come to the issues.
Yes. Issue first, whether the suit is ventilable.
You see, we are concerned with which issues so far
Yes.
as your this.
Yes. 6.
You are concerned with issue number 6 only.
There are
Only.
2 issues more. Whether there is relationship or landlord tenant between the plaintiff and the defendant in respect of premises.
This is
The
one.
main issue. And main issue.
This is the only issue
Only issue.
which we are concerned so far as the entire
Cases concerned.
case is concerned, and all the substantial question of law will be covered by that issue. Correct?
One
All the
substantial-
substantial question of law
One
will
substantial provision of law regarding the suit property is absolutely different from the sale deed itself.
there is no such substantial question of law.
No.
We will not go beyond.
Okay, I will address the.
Just a moment. Which pleading, which according to you, so far as first substantial question of law, which pleading has been taken into consideration? What is the finding of the court which is beyond the pleadings?
Yes.
Which is that finding which is beyond the pleadings?
Yes, lots. The first the trial court judgment, paragraph 18, inter page 12.
Just a moment. Before we go to that, you covered this issue number 6. Let us see what is the finding of the trial court with respect to issue number 6. What is the finding?
At paragraph 18, at page 30 of the trial court judgment.
Para number 18.
18, at page 12.
Yes, please read it.
Even if the plaintiff proves his title but fails to prove the existence of relationship or landlord tenant, suit for eviction will fail. Plaintiff is bound to prove himself as landlord within the building of Section 2F of the Act of 1982, showing his entitlement to receive the rent. Admittedly, no written document with respect of tenancy has been brought on record. So far as the oral evidence is concerned, PW2 in paragraph 8 and 9 of his cross-examination stated that he has heard the fact of tenancy from Anand Prakash, who used to tell his entitlement to receive the rent of ₹60 per month. He also admitted that on the basis of information given by Anand Prakash, he gave his evidence regarding deferred of payment of rent. Similarly, PW3 paragraph 3 stated that the father of the plaintiff disclosed him that the monthly rent of supremacy is 60. He did not have any personal information of the dispute. PW5 in paragraph 8 also admitted that in his presence no transaction took place between Subhash Poddar and Vyasudev, nor he has seen any document. PW7 also stated in his cross-examination not to see any receipt of tenancy. Certainly, evidence of these witnesses are not direct to prove the tenancy of tenancy. Their evidence in support of tenancy is hearsay in nature, including the plaintiff himself, PW6. All the witnesses examined on behalf of the defendant denied the relationship of landlord and tenant. It is quite that fact. Plaintiff has failed to elicit anything substantial to establish the relationship between the parties during cross-examination of the witness. From the witnesses, PW5 in paragraph 7 stated that Vyasudevi disclosed him about her relationship with Subhash Poddar. Evidence of this witness is relevant to show the conduct of said Vyasudevi, who stated that Subhash Poddar as a tenant. Plaintiff in his plaint as well as in the evidence as PW7 6 stated that immediately after purchasing the land, he intimated the defendant to atone him as landlord, and also Immediately, his vendor, Vyaso Devi, requested the defendant to atone the plaintiff and the landlord and pay the rent. Plaintiff remained intact in his cross-examination and no question has been put forward to dispute such content. This fact is also relevant to show that the conduct of the Vyaso Devi who treated the defendant as a landlord and made verbal requests. It has been argued that said Vyaso Devi has not been examined to the suit dependency. It appears from the evidence of paragraph 6 paragraph 6 of the observation that the Vyaso Devi is already dead. Therefore, it is quite reasonable that her evidence could not be adduced in the suit. Moreover, plaintiff purchased the suit in the year 1990. Therefore, he will account for all the events which took place after the purchase of the land and will give evidence prior to that period only on the basis of conduct and information received from the earlier owner. Apart from the above evidence, it appears from the judgment of title suit number 125/1989 in page 49 paragraph 22. While discussing the evidence, it was observed by the court as part of judgment and paragraph 22. Now let us turn to the oral evidence as adduced on behalf of the plaintiff in support of their case. PW1, Subhas Bodha, he is not a party to the suit, claims to be a tenant in a portion holding number 930, that is in a portion of Schedule 1B property. He has stated in an examination in chief that he pays rent to Guru Baks and Dilawar Singh. He remitted rent through money orders. He has proved as many as 28 money orders to market exhibit 1 series. Above discussed evidence made in title suit number, all these are not beyond pleading. As discussed, evidence in title suit number 125 clearly shows that the present defendant Subhas Poddar, who was examined at PW1 in title suit number 125/89, claimed himself to be tenant of Guru Baks and Dilawar Singh, other persons. In the present suit, defendant has claimed himself as a hostile owner, having in adverse possession over the suit property for the last 60 years, but his admission made in 125 clearly falsified the position. Even though the said title suit was dismissed, but it could not take away the admissions made to the evidence by the Subhas Poddar, and also said judgment passed in title suit number 125 is not final, and it has been modified in terms of compromise dated 268/95. Judgment, that very judgment passed in 125/89 is Exhibit 3. May I come to Exhibit 3?
19
To continue
हाँ,
the
continue,
entire
continue. ठीक है. The claimed admitted landlords of Subhas Chandra Poddar, namely Guru Baks, was plaintiff number 2 and Dilawar Singh was defendant number 1. And the vendor of the plaintiff Vyaso Devi was defendant number 4 in 1. And the same suit title suit number 165/89. Further suit property was transferred by Vyaso Devi to plaintiff through registered deed of sale dated 4/4/90 that appears from Exhibit 7, which is a decree of appellate court that the Guru Baks was appellate number 1, and on account of death of Dilawar Singh, he has correspondence number 1A and 1B. The vendor Vyaso Devi was respondent 2, and the present plaintiff was respondent number 5. They will be added. The said appeal 260 of 1995 was disposed in terms of compromise petition, which was made the part of the decree. Compromise petition suggests that it was agreed between all the parties that the appeal, that purchaser of the Vyaso Devi will have absolute right, title and interest and possession of the property purchased by them through registered deed of sale. It was also agreed that neither the appellants nor the heirs of the deceased respondent Dilawar Singh shall have any right, title, interest with respect to property in the suit. Therefore, it is clearly evident that the decree passed by appellate court, the title of the plaintiff over the suit property purchased through Vyaso Devi had already been recognized and admitted and the admitted and not defendant, namely Guru Baks and Dilawar Singh. In light of
So the title, you see, Vyaso Devi was claiming title by virtue of a registered deed.
deed of gift.
Registered deed. There was a registered deed. Maybe gift deed, say deed, whatever with the name.
There is
There was a registered deed of 1990. It was
1990 by a sale deed in favor of plaintiff.
sorry. So there was a registered deed in favor of Vyaso Devi, maybe a gift deed. And it was that particular gift deed which was accepted as valid in the compromise. By virtue of compromise,
That very sale deed in favor of the
see,
plaintiff.
in a case where there is a compromise and one party who is holding some title is passing the title to somebody else through compromise, then that particular compromise decree is required to be registered. Correct? As per the Registration Act, as I understand. But if the compromise by itself is not passing title on anybody, it is recognizing the title which is already existing, then that particular compromise decree is not compulsorily registered.
Absolutely correct.
Correct?
Yes.
So therefore, if we see our third substantial question of law,
Now, I also from the compromise itself, that is a transfer.
no,
Transfer title.
this is not transfer of title.
I
It
was-
is being transferred from whom?
By Dilawar Singh and Guru Baksh.
No, Dilawar Singh and Guru Baksh Singh
They are
has-
transferring their interest,
No,
title.
they are not transferring their interest because there is already a registered gift deed in favor of Gyasudevi,
Yes, they.
right? When there is
There
already
is
a
already
registered
registered
gift
deed in
deed,
favor of plaintiff. They are recognizing the plaintiff's deed.
that's right. So when there is already a registered gift deed in favor of Gyasudevi and Gyasudevi is not giving up that title, they acknowledge the title of the appeal that the purchaser of Gyasudevi will have absolute right title. So
Purchaser
there
of-
is also a registered deed in favor of the plaintiff from Gyasudevi. From where do you say that this particular compromise decree is amounting to transfer of title? You read, when you come to exhibit, which exhibit is this?
Exhibit 3.
Exhibit 3.
Exhibit 6. 6 yes, sir. Compromise decree. Sir,
Yes. Where is exhibit 6 is the sale deed.
seal deed. I will.
Where is the compromise deed?
Sir,
Exhibit 7.
7. At page 4.
Yes, actually, it is there.
Of the compromise. That the plaintiff appellants on receipt of a sum of rupees 6,72,000. 6,72,000 while following bank drafts. These are the
No, you read it from
Ah,
para
different.
1. You read it from para 1. The compromise deed.
Para A.
Para 1.
1.
Where the plaintiff
That the plaintiff's appellants have filed the above appeal against judgment and decree dated 29/9/95, passed in the title appeal number, title suit number 125 of G9 by Sri Takeshwar Pathak, Subject Server, Ranchi, dismissing this suit filed by the plaintiff appellants. That at the intervention of the will be served, the parties have combined the suit and appeal on the following terms and conditions: that the entire property in suit have already been sold by Srimati Vyasu Devi, respond number 2, to Srimati Sumitra Gupta, Sri Prakash Gupta, Sri Anand Prakash Gupta, the plaintiff, Sri Ved Prakash Gupta and Indu Gupta, and Sri Shiv Kumar Gupta, through registered deeds of sale, as well as by Gauri Devi, the own sister of the Vyasu Devi. Respond number 3, to Srimati Dulli Devi through registered deed of sale, and the said purchasers have absolute right, title, interest, and possession over this respective property purchased by them. The said purchasers shall continue to hold and possess the properties acquired by them through registered deeds of sale executed by respect number 2 and 3 and neither the plaintiff appellants nor the heirs of the deceased respondent number 1, Dilawar Singh, namely, are amongst all good of Dilawar Singh and Harjit Singh, Dilawar Singh nor his heirs, successor, all legal representatives shall have any right, title, interest, any manner of the concern in respect of the property in the suit. That in view of the fact that both the respondent number 1 and respondent 2, Vyasu Devi, and respondent 3, Samriti Gauri Devi, have already sold the properties, their interest has been vested into the purchasers, and the respondent number 2 and 3 have no concern with the respect of the property transferred by the respondent number 2 and 3 in regard to the property in this suit. That the plaintiff appellants with Dilawar Singh was plaintiff appellants of this suit on receipt of the sum of rupees 6,72,000, while the following bank drafts, different bank drafts from the suit, totaling about totaling 672,000 from the said purchasers, namely Srimati Sumitra Gupta, Sri Satya Prakash Gupta, Sri Anand Prakash Gupta, Sri Ved Prakash Gupta, and Hindu Gupta, and Sri Shiv Kumar Gupta and Dulli Devi have given up whatever right, whatever right, title, and interest they have had in the entire property in favor of the city. This is the transfer.
So this is not the transfer.
By taking
This
a
is not the transfer because
Really?
they were already existing title.
Right.
Yes.
And, but these Dilawar Singh and Gurbaksh, they are releasing their right.
Releasing their right, the property was already sold.
Sold.
So
But they had right. As per this, they have right. They have some element of title also. And that is even relinquished. For a consideration, specific consideration. There is a contract. There is transfer.
does this compromise deeply acknowledge that they have a title over the property? Does this compromise acknowledge that they have title over the property?
This statement, only they have given up whatever right.
Whatever be it could be possession, it could be whatever. Right, title, interest and possession.
Any kind of interest or title.
This is not a compromise decree by which the title is transferred. The parties are acknowledging that there is already a transfer. Let's see.
This compromise also doesn't recognize the gift also.
Sorry.
This entire compromise.
And this amount, you just see how is the transaction going on. Vyasu Devi had transferred to Sumitra Gupta, Satya Prakash Gupta, Anand Prakash Gupta, and Ved Prakash Gupta and Hindu Devi Gupta, right? She had transferred this property, and through this compromise, they are taking the money from the purchaser. Yes.
Purchasers, yes.
Yes, they are taking the money from the purchasers,
Who?
acknowledging that there is already a transfer.
Said persons, Vyasu Devi and they are taking money. They are
taking
releasing
money.
their right.
No, they are not releasing their right. They have already transferred it.
They have earned.
They have already transferred it by virtue of registered sale.
They have earned.
They have.
They have.
Vyasu Devi has transferred it by way of registered sale deed
Sale deed.
in favor of these persons.
These persons.
Correct? And who is giving this money? This money is given
All the
by the
purchasers.
purchasers. So,
To other person.
no, not to other person.
Yes, plenty of are different persons. Satpal Singh and Satpal Singh and Gurbaksh were other plenty.
So, once the property is already transferred, then
And after that, subsequently, that right was purchased from different persons.
who was the plaintiff in the earlier suit?
Earlier,
Who was the plaintiff?
Relative by Satpal. First page of the compromise deed itself. हाँ बाद में एफिडेविट में भी दिखा एफिडेविट
See, you read the next sentence also. That the purchaser from respondent number 2 and 3 shall continue to hold and purchase the respective properties acquired by them through registered sale deed. So they have already acquired the suit property by a registered sale deed. So where is the question of another registry with respect to the same property?
What was the occasions unnecessary of this that very transfer by way of knowledge and
We do not know why you enter into compromise. We are looking at the fact whether there is a transfer by way of compromise. If there is a transfer by way of compromise, then it is compulsorily registerable. But there is already an existing deed showing transfer. A registered deed showing transfer. So where is the question of again transferring the same property to the same purchaser?
it is happening in the
What happened? It is not compulsorily registerable. We are only concerned with that whether it
If
is
it's-
compulsorily registerable or
if
not.
it's it is not compulsory transfer. They are not transferring. Okay? Satpal Singh and Gurbas were not transferring. How come the defendant of this suit became their tenant atonement? How atonement if it is not a transfer? Atonement कहाँ होगा?
व्यासो देवी
ठीक है व्यासो देवी ठीक थी वो देंगे कोर्ट क्या बोल रहे कि जो सतपाल
नहीं ये पहले तो ये देखते हैं कि whether this document is compulsorily registered.
May I cut short there?
Yes, yes.
Your Lordship may see section 17 itself.
Like this. Section 17.
17. One, Your Lordship may have repeatedly read, but I'll only start. The following document shall be registered if the property to which it's situated so and so, so and so. And then B and C are these two documents. That means other non-transformative instrument with purport or operate, create so and so, and which is valued at over 100 rupees. And other non-transformative instrument which acknowledge the receipt of payment of any so and so. Then Your Lordship may kindly see the exception. That means these documents are required to be compulsorily registered. Now, subsection 2, subsection 2 itself may be seen.
Yes.
Nothing in clauses B and C of section 1 applies to, and what it does not apply, then Your Lordship may see compromise decree, subclause 5, 2.5.
Yes.
No, 2.6.
Yes.
Any decree or order of a court, except a decree or order expressed to be made on a compromise and comprising of immovable property other than which is the subject matter of a suit or proceeding. So there are interpretations of our own the Supreme Court also. What it says, ultimate interpretation is that if the compromise is with regard to the suit property, then it is not required to be registered. But if the compromise, by that compromise, a third property is being included in the compromise between the parties, then that document is required to be registered. Otherwise, if this compromise relates to the suit property, it is not compulsorily registered.
No, suppose there is a suit
Yes.
by which the plaintiff is claiming adverse possession. And there is a compromise by which on payment of money, the defendant acknowledges the title of the plaintiff. Not by way of adverse possession, but by way of some consideration which is passing through the decree. That decree is compulsorily registered. Because by that decree, the title is passing. If the title passes by virtue of a decree, then that decree is compulsorily registered. But
Yes. I do get your lordship.
But if the compromise is acknowledging something.
Yes, then.
If the
this was
compromise is acknowledging some kind of
my-
already transferred
Yes,
property.
my
then it is
submission
not.
was only in exceeding what your lordships have already observed, that it was already acknowledging a title which was already passed, transferred.
Whatever be the transaction
Yes,
in
yes,
terms
yes.
of money, that is
It was
irrelevant.
only acknowledging. So
Because the property being transferred to Mr. Gupta's and company, who all
Yes,
are there,
yes.
who purchased the property.
yes,
That the stamp duty on that is already paid.
paid. Yes, yes.
The whole purpose
It is-
of registration is that the marking should be there and stamp duty should be paid. So that stamp duty, whatever was the amount payable, was already paid. By this decree, they are only acknowledging some kind of, they are buying peace by transferring some money.
That's
That is it.
yes.
So that
Now,
does
Your
not
Lordship,
mean that
if-
it is compulsory
If the
registered.
manner in which this question has been raised, there are many compromises. All those would now would be seen as if now what is the purpose? Whole purpose is to settle the litigation and
That's right.
where the parties are.
And parties are, they are not transferring by way
Yes,
of
yes,
compromise.
yes.
They are
They're settling
acknowledging
their
the
dispute.
transfer. They are
Yes,
settling their transfer.
They are acknowledging that it was already transferred
That's right.
and their only acknowledgement is there.
So this particular plea नहीं चलेगा. Compromise decree
ठीक है उसका दूसरा था अब
इसको इस प्ली को खत्म करिए उसके बाद दूसरे में शिफ्ट करिए. Is it okay so far as this is concerned, or you want to address something more on this? Because prima facie on the basis of compromise, it does not appear that there is a transfer of property. You see, what is happening in Jharkhand is that there are Mr. Gupta and to you also, I have come across one matter where there is a suit for specific performance agreement. And ultimately parties enter into a compromise in the suit saying that okay, we settle it for such and such consideration or no consideration. Now the title of the purchaser, the vendor as per the agreement, the vendee as per the agreement is acknowledged by the vendor. Right? Then under such circumstances, if it ends into a compromise, then the court will not execute the sale because
Yes.
the parties have settled their dispute.
Yes,
Such kind of compromises are compulsory for registry.
yes, that.
Because that is transferring the property.
Transferring, because the suit itself was that suit must have been for specific performance.
Yes.
Transfer from the
That's
vendor
right.
to the purchaser,
Yes.
and in that the compromise cannot be that you.
That I acknowledge your
Yes.
title number. For whatever you say.
Yes.
So if any compromise is entered by which the title is transferred, then that is compulsorily registerable. But if the compromise is there which acknowledges the title which has already been transferred,
Yes, yes.
then that is not compulsory.
Then
If you have any judgment on this, if you want to cite anything, you tell us. First, I will decide this issue. This substantial question of law, I will decide at the threshold, and then we proceed. Yes, sir. You provide me the copy. Book C.
सेवन अभूप सिंह
आप नहीं लाया था सही के लिए.
हम निकाल दें.
निकालिए.
Because I have another one which is directly based on.
ये सेवन पैराग्राफ
Read
सेवन
para 19 and 20. You want to
First
read para?
17, first 17. It would therefore be the duty of the court to examine in
Para
each
17.
17,
17.
17.
Yes, sir. Read it.
It would therefore be the duty of the court to examine in each case whether the parties have pre-existing right to the involved property or whether under the order or decree of the court, one party having right, title or interest therein agreed or suffered to extinguish the same and created right, title, interest in presenti in the immovable property of the value of rupees 100 or
Exactly. When
They
there is
have right.
already a registered deed by which the property is transferred, right?
But some
By virtue of this compromise, no new right is being created.
not they, but some other persons who have not executed any deed prior deeds, they are extinguishing their
No,
rights.
this is not there that they are extinguishing. They say that this property is already transferred. Now they are getting some money from this the purchaser of the property.
And I would again with seven.
Exactly what your lordship said. In
Uh,
para 18 also.
uh, um,
You just tell
Satpal
us
Singh
one
and
thing. You just tell us one thing. There is a registered deed of sale by a co-owner of the property. Correct?
mm,
If that registered deed of sale is not set aside,
not
right? And the co-owners and everybody, they enter into a compromise that okay, this registered deed of sale is there, I acknowledge it, and there is some
and we are
transaction
taking
of money.
we are taking these money
Whatever it
purchasers
is.
and we are releasing our rights.
No.
May I
You see, it makes no difference. The property is already transferred. They are acknowledging the transfer. That is important.
when there is consideration more than 100 rupees, that requires a compulsory register.
No, this is not compulsory.
Okay. I'll move to the another.
And that too in a proceeding under BBC Act. There is a limit to which we can actually adjudicate the title of the parties.
I'm not going to that on you. Now exhibit 6. No.
This part is over, you want to say something more on this?
This is the job.
I'll answer it just now. I'll answer it just now. This appeal has been filed against the judgment dated 26th of June 2025, within bracket decree signed on 4th of July 2025, passed in civil appeal number 43 of 2019, by which the learned Additional Judicial Commissioner 1 cum Special Judge PMLA Ranchi has dismissed the appeal. The trial court judgment is dated 7th of January 2019. Decree signed on 21st of January 2019, passed by learned Munsif Ranchi in eviction title suit number 22 of 1999, whereby the suit was decreed in favor of the plaintiff. The defendant has lost in both the courts and has filed this second appeal. The second appeal was admitted on the following substantial question of law by the order dated 12/8/2025. The learned counsel for the appellant at the threshold has addressed this court with respect to substantial question of law number 3 and has submitted that the unregistered compromise decree passed in first appeal number 268 of 1995 within bracket R was compulsorily registrable under section 17 of the Registration Act, and the same having not been registered was inadmissible in evidence. He submits that the compromise decree was one of the materials which was taken into consideration to hold that the plaintiff had title over the property by deciding the issue on the point of landlord-tenant relationship. The learned counsel has placed the compromise decree passed in the aforesaid appeal which was marked Exhibit 6, Exhibit 7 before the learned trial court, numbered as first appeal. The exhibit is numbered as first appeal number 268 of 1995 within bracket R. He has referred to the terms of compromise and has submitted that by virtue of the compromise, there has been certain monetary transaction between the plaintiff and the purchasers of the property from one Vyaso Devi, who was respondent number 2 in the first appeal. The learned counsel submits that by virtue of this compromise decree, there is transfer of title and therefore the same was compulsorily registrable. He has referred to the judgment passed by Honorable Supreme Court reported in Wood Singh versus Ram Singh Major and others, bracket 1995, bracket close 5 SCC 709, and has referred to paragraph 17 thereof. The learned counsel for the respondents, by opposing the argument of the petitioner of the appellant on the third substantial question of law, has submitted that by virtue of compromise, no title is created in favor of the purchasers from Vyaso Devi, inasmuch as the recital of the compromise itself reveals that the suit was already transferred by Srimati Vyaso Devi in favor of the various purchasers through registered deeds. And the said purchasers already had the absolute right, title and interest and possession with respect to the properties purchased by them. He submits that since there was no transfer of title by virtue of the compromise decree, the same was not compulsorily registrable, and he submits that the judgment cited by the appellant in fact is in favor of the respondents.
And no, the compromise decree was not creating rights for the first time.
The learned counsel submits that the compromise decree was not creating any right for the first time in favor of the purchasers from Vyaso Devi.
Yes.
After hearing the learned counsel for the parties on the third substantial question of law, and upon going to the compromise decree, which was marked Exhibit 7 before the learned court, this court finds that the compromise decree itself reveals that the property was already sold by Vyaso Devi by way of registered sale deed. And there was no creation of any fresh title in favor of the purchasers from Vyaso Devi. The deed in their favor was already registered. This court, in the judgment passed by the Honorable Supreme Court in the case of Wood Singh Supra, it has been observed in paragraph 17 that it would be the duty of the court to examine in each case whether the parties have pre-existing right to the immovable property or whether under the order or decree the court, one party having right, title or interest therein agreed or suffered to extinguish the same and create right, title or interest in presenti in immovable property. For the first time through compromise. This court finds that the compromise, that the property having already been transferred in favor of the purchasers, the compromise decree was not creating any right, title or interest in favor of the purchasers for the first time through the compromise decree. And accordingly, this court is of the view that the compromise decree was not compulsorily registered. 10. The substantial question of law number 3 is answered against the
Three make
applicant and in favor of the respondents. Or the-
three make और पार्ट है सबसेशन नंबर 3 में एटनमेंट वाला पार्ट भी है
Yeah.
सबसेशन क्वेश्चन नंबर 3 जो है उसमें
Yes.
एक और पार्ट है एटनमेंट वाला नो नीड ऑफ एटनमेंट
Adornment we'll see. 3, that is not a part of substantial question of law number 3.
यस वेरी
This court is of the view that so far as the point of adornment is concerned, the same which has been mentioned in substantial question of law number 3, the same will be separately considered. Of adornment.
अब उसमें आया बेसिकली लैंडलॉर्ड इसी एग्जीक्यूट 7 at page 6 एग्जीक्यूट 6 का ही फॉर्मल डिग्री का ही at page 6 कुछ दिखाना चाहता हूँ
Page 6 or
फॉर्मल डिग्री कॉम्प्रोमाइज
page 6.
7 एग्जीक्यूट 7
Exhibit 7. Page 6.
Clause F. That the purchaser Shiv Kumar Gupta is not the plaintiff of this one. From respondents number 2 and 3 shall also be entitled to realize rate from the tenants in occupation of the property in the suit, including all the areas of rent, and shall also be entitled to file suit and proceed for their adjustment and for determination of fairness without any late interest, interruption, claim or demand by of the affiliates and the number 1A, 2, 3. There is no such clause for the plaintiff. He is also purchaser.
Plaintiff is a party in this compromise.
Plaintiff Anand Prakash Gupta. He also paid money.
Who is the plaintiff?
Anand Prakash Gupta.
Anand.
At page 4 उसका नाम आया हुआ है सत्य प्रकाश गुप्ता मतलब विकास गुप्ता इंडिविजुअल शिव कुमार गुप्ता he also paid but शिव कुमार गुप्ता के बारे में एक पर्चे बड़ा स्पेसिफिक है कि उनका वो टेनेंट उनका है उनको राइट मिलेगा पर ये पर्चे के बारे में जो ये इसके प्लेंटिफ उसके बारे में
I don't get it. You see, these bank drafts have been paid by whom?
Also Anand Prakash Gupta at page 5 from the purchasers this amount from the purchasers namely Srimati Sumitra Devi Gupta, Satprakash Gupta and Sri Anand Prakash Gupta. He is the plaintiff of this one. Sri Vedprakash Gupta and Lavi Shiv Kumar Gupta, that way Shiv Kumar Gupta and Dulli Devi had given up their whatever right. And there is no such stipulation.
Who has given up? They are the purchasers from
Purchase-
Vyasudevi.
Vyasudevi.
Yes.
And one of the purchasers, Shiv Kumar Gupta, is also a purchaser.
Yes, Shiv Kumar Gupta is
There is
also
specific
purchased.
stipulation in clause F that the purchaser, only purchaser, Shiv Kumar Gupta from respondents number 2 and 3 shall also be entitled to realize rent from the tenants in occupation of the property in this suit, including the all areas of rent, and shall also be entitled to file suits and proceeding for the adjustment and for determination of fair rent without any late hindrance in terms of claim or demand.
So, irrespective of who purchased the property, with respect to the entire property, there was one sale deed or there was multiple sale deeds?
Multiple, various.
Multiple sale deeds. So far as this particular
Multiple.
property is concerned, right? It is in relation to which sale deed? Sale deed in favor of
Anand Prakash Gupta.
Anand Prakash Gupta. So you want to say that by virtue of this particular compromise decree, Anand Prakash Gupta, Prasad Gupta has given him his right to claim as a landlord of the property.
There is no such stipulation as Shiv Kumar Gupta. He is also a purchaser, but there is
Maybe there is no specific, that is, atonement is not necessary.
एटोनमेंट नहीं, हम एटोनमेंट नहीं दिखा रहे, हम दिखा रहे हैं यदि वो होते टेनेंट इसमें, इसके टेनेंट होते हैं डिफेंडेंट के, तो ये क्लॉज इसमें भी रहता। शिव कुमार गुप्ता में टेनेंट है, तो साफ साफ लिखा गया है कि वो टेनेंट का राइट है कि वो अपने रिलायंस के रेंट को एविडेंस में फाइल करे, पर देयर इज नो सच स्टिपुलेशन रिगार्डिंग आनंद प्रकाश गुप्ता।
So you want to say that there is no relationship of landlord?
अब आ
No, just a moment. Is it in dispute that the property in which you are residing or you are having, that stands in the name of the plaintiff? Is it in dispute?
No,
It is not in dispute.
no.
Is it in dispute that you were originally the tenant of Gyasuddin?
Yes, this is dispute. I have never been. The London trial court did make a different case that I have admitted that I was a tenant of Dilawar Singh and Guru Baksh Court. And different case on matter. I will come to that. I have always the trial court has
So you want to say that this particular clause reveals that
if there be a tenancy,
what is the name of the tenant? Anand Prakash.
tenant का नाम है सुभाष चंद्र गुप्ता,
Subhash.
जो डिफेंडेंट है।
Who is the name of the defendant? What is the name of the defendant?
सुभाष चंद्र गुप्ता,
Subhash.
सुभाष चंद्र गुप्ता। And the
So by virtue of this clause, you want to say that you were not the tenant of Anand Prasad.
Anand Prakash Gupta. If that's so,
Then if you were the tenant of Anand Prasad Gupta, then your name should also have been there.
no, at least Anand Prakash Gupta's name.
So you want to say that there was no tenant in the premises of Anand Prasad Gupta, right?
Right. Now come to the sale deed itself. Exhibit 6.
Just a minute. Yes.
Exhibit 6. The sale deed. The basic sale in favor of the plaintiff and product by the association.
This is dated.
Dated 9990. 4490. 4490.
Exhibit 6.
6.
Yes. What do you want to say?
At its page number 7.
Page number 7. Yes.
This sale deed is was executed by the Vyasudevi in favor of the plaintiff. Page number 6, running page 6 of that sale deed. Last item. And the vendor doth hereby covenants with the purchaser that the properties hereby conveyed, sold and transferred absolutely forever are free from all incumbents, trust, liens, lease pendants, tenancies. Free from tenants. This is the admitted document. This is free from. And again back to the door purchase. judgment.
Just a moment. The learned counsel for the appellant, while advancing his argument on the point of atonement, has submitted that
On the landlord-tenant relationship.
on the atonement and also landlord-tenant relationship, has referred to the compromise decree and submits that although there were several purchasers, including Anand Prasad Gupta, in bracket, the alleged landlord in the present case, from Vyaso Devi, but it was only in connection with one of the purchasers, namely Shiv Kumar Gupta. It was specifically mentioned that Shiv Kumar Gupta will be entitled to realize rent from the tenants in occupation of the properties in the suit, including all areas of rent, and shall be entitled to file suits and proceedings for their rejectment. He has referred to clause number 2 within bracket F of the compromise decree, of the joint compromise petition, which ended in compromise. The learned counsel submits that had there been any tenant over the suit property involved in this case, it would have been definitely mentioned in the joint compromise petition itself that Anand Prasad Gupta would be entitled to realize rent from the defendant of the case, namely Subhash from Poddar. He submits that this itself goes to show that there was never any landlord-tenant relationship between Anand Prasad Gupta and Subhash Chandra. He has then referred to Exhibit 6, which is the sale deed executed by Vyaso Devi in favor of Anand Prasad Gupta, and which involves the suit premises involved in the present case, and has referred to internal page 6 of the sale deed to submit that it was specifically mentioned therein that the property so transferred to the sale deed was free from all encumbrance, trust, lien, lis pendens, tenancies. He submits that this itself indicates that the defendant in the present case was never a tenant of Vyaso Devi and therefore was not a tenant of Anand Prasad Gupta, who had purchased the suit property from Vyaso Devi. Yes?
Now back to the lower court. At paragraph 18, I volunteered. उसमें किस तरह का कोई आया नहीं है, डॉक्यूमेंट एविडेंस नहीं आया है, डेपोजिशन नहीं आया है, किसी तरह का एविडेंस नहीं पाया गया है कि इसमें रिलेशन से नेटवर्क दिखता है, ये बात आ गई, हम पढ़ चुके हैं इसको, पैराग्राफ 18 में वही डील किया गया, पेज 13 का मिडिल पार्ट हम फिर से पढ़ेंगे. It is quite certainly the evidence of these witnesses are not direct to prove the fact of tenancy. Their evidence in support of tenancy is hearsay in nature. All the witnesses examined on behalf of the defendant deny the relationship with the landlord tenant. It is quite that fact. Plaintiff has failed to elicit anything substantial to establish the relationship between the parties during cross-examination of the witness. From the there is nothing. All that are hearsay. And not a single sheet of paper was filed.
No, plaintiff was examined and there was no cross-examination of the plaintiff on this point. This has been taken into consideration by the judge.
On what point?
Plaintiff in his plate as well as in his evidence as PW6
Happy
stated
to
that
see
immediately
here,
after purchasing the land, he intimated the defendant to atone him as landlord And also immediately his vendor, Vyaso Devi, requested the defendant to atone the plaintiff as landlord and pay the rent. Plaintiff
Remain intact.
remained intact in his cross-examination and no question has been put forward to dispute such a conduct.
Dispute or some conduct. पर ये आ गया है कि plaintiff has
This fact is also relevant to show that the conduct of vendor Vyaso Devi, who treated the defendant as a landlord and made verbal request.
पर ये चीज आ गया है कि the plaintiff has usually failed to establish the any kind of relationship or landlord and tenant. ये
Is the defendant claiming title over the property?
yes.
Yes, please.
By way of adverse possession.
By your
Adverse possession.
way. You have established your adverse possession. Is there any substantial question of law on adverse possession?
No.
Then
only landlord relationship will come.
sorry.
landlord relationship.
Sufficient. They have the
वही
title
बस
over the
हम
property.
ये नहीं दिखा रहे, हम कहाँ बोलने नहीं आ रहे थे क्या किसमें है, हम उसको एस्टेब्लिश हम उसको डेमोलिश करें प्लेंटिफ का केस बस ये यहाँ तक नहीं कर पाए. What the trial court as well as the first appellate court, that they have taken a totally different case, that I have admitted in some proceeding 125 or 189 as a witness, the defendant of this suit, that I used to pay rent money order to Dilawar Singh and Guru Baksh, and therefore I am the tenant. Yes, tenant. Anand Prakash Gupta. That is the finding of the court. Complete different case. ये कभी नहीं आया ना गवाही में आया कुछ नहीं है और इसके ऊपर एविडेंस भी लीड हो गया वो डॉक्यूमेंट आ गया.
You claim that you are a tenant of Dilawar Singh. You don't claim that also.
No.
That is not your case.
I'm not claiming. The lower court said that I have admitted whether that the oral evidence mentioned in the judgment can be treated as a admission or not, that will come. But the question is that whether I am the tenant of Anand Prakash Gupta or not, or Vyaswati.
You see,
And what the lower court did at page, at very next page 14.
now you see,
Peter. Not so.
you cannot have it like this. You have to stick to the substantial question. Correct?
Yes.
Okay.
Substantial question of law is that what is the admission? Is
No.
it?
There is no substantial question of law
Yes.
and where there is an admission. With respect to substantial question of law number 2,
Not so.
you address on substantial question of law.
Two, adjournment.
No, not at all. In absence of certified copy of deposition, whether the statement recorded in the judgment could be treated as an admission.
Also, that very that can be treated as admission. What about 145? That will be
So we will not go into that. You see, whether any observation
statement,
made
observation in the
in
judgment.
suit number 149 of 1989 could be treated as an admission.
Admission. And whether that part of deposition mentioned in the judgment itself can be an admission without confronting me that very deposition while
That's
being
it, it's the
examined.
same thing.
145 will be the evidence. And, page 14 of the judgment. The case I made out that fourth line from top. It appears from the judgment 14 of the judgment. It appears, third line from top. It appears from the judgment, the title suit number 125 or 89 in page 49, paragraph 22, while discussing the evidence, it was observed by the court as, now let us turn to the oral evidence adduced on behalf of the plaintiffs in support of their case PW1 Subhash Chandra Poddar, the defendant in the suit, claims to be a tenant in a portion of holding number 930, that is in a portion of Schedule 1B properties. He has stated in his deposition examination in chief that he pays rent to Buxkor and Dilawar Singh, and he remitted rent through money orders. He has proved as many as 28 money orders coupon marked and exhibit on CDH. ये इनका एडमिशन मांग रहे हैं। अब सीधे हम जो 3 एग्जीक्यूट 3 इज द जजमेंट।
No, let's take it. It is there.
ना वो तो ठीक है, उसके आगे तो नहीं, उसके छुपा दिया ना, उसका क्या है इसका कोई ब्रांडेड कोट नहीं, फाइंडिंग में ही उनके बारे में कुछ बोल दिया, उसके बारे में आगे बढ़े at page 49 of the judgment.
Exhibit number?
3.
Space 3. Just a moment. Which paragraph do you want to read?
22 at page 49 of the judgment.
This is title suit number 125 of 1989,
Yes.
which ended in a compromise.
एंड इसी बुक का पोर्शन लेके एडमिशन बोल रहे हैं कि हम दिलावर से क्या और
उसका कोई relevance नहीं, भूल जाइए।
तो यही
Irrespective of that evidence, whether the judgment will sustain or it will not sustain.
हाँ तो यही उनका तो यही है कि हम मान लिए उसका
नहीं बात ये है कि irrespective of this particular document, right, which ultimately ended in a compromise, right, whether any statement therein or recording therein could be taken as an admission,
evidence on.
right, but the judgment is not solely based on this evidence. The judgment is made based on multiple evidences placed on record.
I am not going to the judgment. I am going to the part of the my statement recorded as a witness.
Let's take it that it could not be taken into consideration. Can this be the only ground to set aside the judgment? To set aside the impugned judgment?
No.
So that's it.
Can that statement can be taken as evidence admission or not? That's
Mr. Gupta, you see, this particular suit ended in a compromise. Can such selective statements, etc., can be picked up from the judgment and used against the defendant in this present case?
That way I have difficulty. I will not shy away from answering that. But Your Lordship, the trial court and appellate court's discussion may continue with regard to some other thing.
No, we will see that. But this piece of evidence.
Why? Your Lordship, firstly I must concede that if he was admitting himself to be the tenant in the same property, that means plot number 930, then we were required to take out that deposition itself, and we should have
confronted.
Yes, absolutely. I'll not shy away. But Your Lordship, section 114 is also there of the Evidence Act, which says that if the judicial act is performed, it it shall be presumed that it has been performed.
But in a
No,
case,
I'll
which has
come.
ended
I'm
in a
answering
compromise. Yes.
to that. Now, Your Lordship, on the date, it has not, your compromise is subsequent to passing of this judgment. So, on the date when the judgment was passed, there was no compromise. The trial court judge, he mentioned that PW1, Subhash Chandra Poddar, says so and so, makes his statement that he is a tenant. This is very important. Now he is claiming himself to be a person in adverse possession. Impliedly, therefore, that someone else is the owner. He is not the owner. So, when he says, and the trial court judge records that, and he, whatever discussion is there, but his statement taking note that he has been examined as PW1 and he has said so and so, this presumption has to be there that he has correctly recorded. Now, what would be the consequence? If they were disproving this or disputing this, then they ought to have brought their own evidence certified copy, and they ought to have shown that we have not said so. This is wrong recording of the fact.
The point is that this is wrong recording or right recording of the fact. There are two aspects of it. Firstly, this was in appeal, and at the appellate stage it ended in a compromise.
No, this is not in appeal. The
This
recording of this observation or whatever discussions are there, they are in only by the trial court judge. Subsequently, in appeal, it was.
In appeal, it was compromised,
Yes.
right? In the appeal, they acknowledge only one person as tenant with respect to one of the purchaser of the suit property. There is no further acknowledgement regarding the tenancy with respect to the defendant of the precedents. Right? So his admission that he is a tenant over the property does not exist anymore in view of the compromise in which he is also a party and you are also a party and everybody is there. Right? Then under such circumstances, his status that he was a tenant in the property which was purchased by Anand Prashad Gupta, right? Then it cannot be said that there was a admission on his part and therefore
This fact cannot be seen in isolation.
Cannot be seen in isolation.
I'm answering your Lordship. I understand my difficulty. I said that I'll answer. Now, your Lordship, one thing has to be seen, that the dispute, the title suit we have mentioned in our claim, it related to various factions, and one of them were these two persons whom he himself mentions that they are my landlord. They are the parties in the compromise decree, and the moment there is a compromise and it has been, our right has been affirmed, which in the said compromise, then I get all the right, whatever of the contesting party over the suit property, and that would include the tenancy right also.
if it exists.
Yes, if it was there. But merely because in one of the paragraph it has been mentioned that tenant so and so, with regard to one of the portion it has been mentioned, the other portion of the entire compromise, that cannot be ignored. Now, what is that? The Lordship may see the compromise.
You see, I am looking at the second substantial question of law. Whether picking up that particular recording by the learned trial court, which ultimately ended in a compromise before the learned first appellate, can be taken up as an admission on behalf of the defendant. It can't be.
It can be in one circumstance. I said that it would be presumed that he has correctly recorded, and it was for them. It is an adversarial litigation where I, as a plaintiff, I examine myself first. I produce that certified copy.
In a case which ends into compromise, the decree as well as the judgment of the trial court necessarily goes.
Yes.
Right? If it goes,
I'm-
everything goes.
No
Any
finding.
recording goes.
I'm not relying on a finding, any finding of it. I'm only saying that the trial court judge records a fact that this has happened.
It is just a
That
fact.
means It says that PW1 is so and so, and he has made this statement.
That's
So this cannot go. And it was for them to have brought their own process. We are only relying on that particular recording portion with regard to a
You
fact
are
and
relying
not
upon that recording portion, but that recording portion has gone in the mind of the judge to record a finding. Right? He has recorded a finding by taking into consideration the various materials on record, and that recording in the previous suit is one of the recordings which have been taken into consideration by the court to come to a conclusion that there was a landlord-tenant relationship
no,
between the
only
parties.
what the trial court, in our case, what it has been done. The courts have, the appellate court and the trial court, he only says, they only say that his stand now as claiming himself to be in adverse possession, that is falsified in view of his own statement in a previous suit where he claimed himself to be a
He
tenant.
was
This is all. This is
adverse possession against whom?
again nothing.
Against
All
nothing.
all these discussions are there that so this
To
what he says.
dispel his argument on adverse possession.
Yes, that is the only portion.
That is the only
yes,
purpose.
I'll read out because your Lordship may kindly see running page 69 of the appellate court,
Yes, I'm there.
internal page 14, where my learned friend quoted that particular portion of previous suit has been quoted. Thereafter, after the bold portion, above discussed evidence made in title suit number 125 of 1989 clearly shows that the present defendant Subhash Chandra Poddar, who was examined as PW1 in so and so, claimed himself to be a tenant of so and so. In the present suit, the defendant has claimed himself as hostile owner having adverse possession of the suit property for the last 60 years, but his admission made in so and so clearly falsifies his position. That means he is not a tenant now, which he is saying that he is in adverse possession, even though the said suit was dismissed, but this could not take away the admission made in so and so. The claimed admitted landlord Subhash Chandra Poddar, namely Guru Bhaksh and so, was made defendant number 1 and the vendor of plaintiff Vyasudhi was defendant number 4 in the one and the same title suit number 1981. Further, in the said property was transferred by Vyasu in favor of the plaintiff through registered deed of sale as it appears from Exhibit 7, the decree of the appellate court. Guru Bhaksh was the appellant number 1 and on account of death of Dilawar, his legal heirs were respondent number so and so, and the vendors Vyasu Devi was the respondent number 2 and the present plaintiff was respondent number 5. The said appeal number so and so was disposed of in terms of the compromise which was made part of the decree. Compromise petition suggests that it was agreed by all the parties to the appeal that purchaser of Vyasu Devi will have absolute right, title, interest and possession of the properties purchased by them through the deeds of sale. It was also agreed that neither of the appellant or the heirs of the respondent, deceased respondent number 1, Dilawar Singh, shall have any right, title, interest in respect of the property in suit. Therefore, it is clearly evident from the decree passed by the appellate court that the title of plaintiff over the suit property purchased through Vyasu has been duly recognized and admitted by the admitted landlord or dependent, namely Guru Bhaksh and Dilawar Singh. In the above discussed fact, it can also be said that any defect which was attached with the title of the plaintiff purchased through sale deed dated so and so has been removed and his title has become absolute through compromise decree which was passed in so and so. Inference of relation between dependent and Guru Bhaksh and Dilawar can also be drawn from the cross-examination of so and so, para 11 of PW5 and para 9 of PW6, which shows that it was well within the knowledge of the defendant that Dilawar and Guru Bhaksh were also claiming interest over the suit property. After the transfer and acquiring the title, transferee steps into the shoes of the earlier landlord, Guru Bhaksh and Dilawar Singh, and transferee gets all the rights and liabilities of the earlier landlord in respect of the suit premises and tenancy. Evidence on record suggests that thereafter written notice dated so and so was also issued to the dependent by the plaintiff, intimating him regard to purchase made on so and so, and also the judgment and decree dated so and so, and the request was made to the dependent to adorn the plaintiff as a landlord. Exhibit 1B shows that the notice was issued through registered post. In such circumstances, there is always a presumption of due service. Even if such notice would not have been issued, then also adornment is not necessary condition to create landlord-tenant relationship between parties. It is clear from evidence on record, the plaintiff has established a title, issued notice to dependent about the purchase. It is not the case of the dependent that earlier landlord is demanding rent from him. It is not necessary that the tenant must accept the plaintiff as a landlord and then alone he is liable to pay rent. Rather, after establishment of title by the new landlord, the tenant is bound to pay rent to the new landlord. It is also argued that Exhibit 7, name of only one purchaser, Shiv Kumar Gupta, was mentioned for his entitlement to realize rent from the tenant. Such argument is not tenable on the admitted note of the defendant Subhash Chandra Poddar accepting him as a tenant on the point of transfer of the property in favor of the plaintiff through Vyasu Devi, even if no right of plaintiff mentioned in the compromise petition, it is not in any way derogate the right of the plaintiff as landlord to recover the suit and sue for service.
It was basically to dispel his claim for adverse.
Yes, that is the essential reason for
Referring
mentioning that in earlier suit they had claimed themselves to be tenant, whereas in this suit they are claiming themselves to be the adverse.
And in
And-
the present case, they have pleaded against whom they were claiming adverse possession.
No, absolutely
The date of possession, the
no, nothing. And that has been disbelieved by the courts below, that they have been able to establish their right. They have not been able to establish their right as persons claiming adverse possession. So, Your Lordship would recollect that the moment a person takes a plea of adverse possession, there is an implied plea that someone else is the owner of the property. And he does not even disclose as to who was the owner of the property, against whom he was seeking.
basic foundational plea for claiming adverse possession
Yes.
was totally absent.
Yes, absolutely. And there are no equities in favor of the person claiming adverse possession.
Do you want to say anything to this? You were claiming adverse possession?
I have claimed, but I am
Against
not on
whom?
that.
Against whom?
Against everyone who is claiming that.
Since when were you in possession? And what
More than
of,
60 years, I have been.
have you given the foundational pleading regarding your adverse possession?
No, not simply.
It's not there. So this particular discussion is only to dispel your plea of adverse possession and nothing more.
That is not true. That is not true. The learned trial court and the appellate court has made out a different case that I have admitted that I was a tenant of the Lavar Singh and Guru Bhaskar, and therefore I am also a tenant of this very person. This is the only matter. What the discussion is had been in the imprisonment itself. उसका जो आगे वाला पार्ट है मुझे फर्स्ट दिखाना चाहिए एग्जिबिट 3 जो बोले हैं उसको एग्जिबिट 3
What is exhibit three?
जिसका पोर्शन डिस्कस किया गया है
उसका तो
नहीं वो तो ठीक है वो
you
हो
see, I
गया
tell you one thing, nothing could have been relied from this judgment.
ठीक है नहीं आगे
I
आगे वाला
think-
पार्ट को किस लिए छुपाया गया है वो दिखा आगे वाला पार्ट को उन्होंने डाल के छुपा दिया है
हम उसको it was not admissible in evidence. A judgment which ended into a compromise, उसका finding का उसका discussion का क्या
if
relevance?
that is not a reservation
It is absolutely irrelevant.
then both the courts below have clearly found that there is no relationship and not here between the parties as clear.
There is a finding of both the courts that there
Both
is
the
no
courts.
relationship.
And there is a different case on the basis of that very so-called admission that I was a tenant of Lavar Singh. I have admitted I have a tenant at Lavar Singh and
was called. Therefore, a tenant is always a tenant. That is the fact. Both the courts are of same opinion. All the evidences brought by the on behalf of the plaintiffs are all those hearsay, and nobody said anything regarding any transaction of rent or any document has been brought. Case 12 of the Court for Judgment at Para 18. Discuss it later. Namely, if the plaintiff was to establish his own case, and therefore a suit for tenancy, the suit for non-court was to use the relationship and not tenant first.
Let me see which portion of this judgment you are referring to.
18, paragraph 18.
Para
18 of the judgment.
18.
Jharkhand.
At page number?
At internally page number 12
Of which judgment?
of the trial.
No, this
Judgment.
trial,
Ach.
which is exhibit 3. Let me just have a look at
Exhibit 3 at
what-
page 49.
Which paragraph I read?
22.
Para 20. Yes. Which paragraph are you talking? Why do you want to refer this? You say that the entire thing has not been taken into consideration by the court. Which portion has not been taken into consideration?
Now let us turn to the oral evidence adduced on behalf of the plaintiff in support of their case. PW1 Subhash quoted in the trial judgment. PW1 Subhash Chandra claims to be a portion of Schedule B property. He pays rent to Gurbaks and Dilawar Singh, and he remitted rent through money orders. He has proved as many as 28 money order coupons marked as Exhibit 1. In his cross-examination, he has admitted that there is no seal of the no seal of the post office in any of the money order coupons. He has further stated that the corresponding plot number of the holding number 930 and 1361. This part of the evidence is incorrect. There is no disputed plot number 1361 in the schedule to be plain. कॉन्वाइज हुआ था उसमें ये था भी नहीं. This document has not been produced for document of tenancy. He has also not produced any counterfile of the rent receipt. The money order coupons proved by him do not bear the seal of the post office, which has been admitted by this witness. The name of the address of the witness addressee does not find place in the money order coupons. The money order coupons are not submitted by postal received not even a single question on behalf of the plaintiffs and such united purpose cannot be prepared, can be prepared at any time. Although he claims to have a payment of rent to the Lower Singh, but it is curious enough that the Lower Singh has not come forward to support the case of the plaintiff. ये सब तो बात है कि ये जो इस पार्ट को ले लिए खाली हम उनका क्लेम माने जो भी और प्लेंटिंग बोल के
The evidence of this witness
Evidence?
is of no assistance.
no assistance on our part.
Is an error. This witness, you want to say, was not believed. by
Believed
the court.
also by the court itself. और एक portion को ले लिया गया जो the document and the deposition of part of deposition has also not been produced. No such preceding is there in the printout. That is not the basis of the case of the plaintiff. Plaintiff is just on case. That is my case. We have immediately framed the plaintiff and immediately tried to establish the relationship between him and not only between him and the defendant, also between Vyasu Devi, his header, and the potential defendant. And apart from that, we section 145 of the evidence that no such a statement has been confronted by examination. PW6.
145.
145 of the evidence. They add essence also of the on the words of the input.
With respect to second substantial question of law, the learned counsel for the appellant has referred to paragraph 22 of the judgment passed in title suit number 125 of 1989, which ultimately ended in a compromise at the first appellate stage. He submits that the learned trial court in the present case has selectively quoted from paragraph 22 of the same judgment, and upon reading of the entire evidence as recorded by the court in title suit number 125 of 1989, to the extent it discusses the evidence of Subhash Chandra Poddar, the claim of Subhash Chandra Poddar to be a tenant was, the evidence of Subhash Chandra Poddar was not accepted by the court. The learned counsel submits that if the plaintiff of the present case wanted to rely upon the evidence of Subhash Chandra Poddar deposed in the state title suit number 125 of 1989, then the certified copy of the deposition ought to have been brought on record, and the defendant should have been confronted with such statement. He has referred to section 145 of the Evidence Act. The learned counsel submits that the deposition from the selected reliance of the recording of the learned trial court in title suit number 125 of 1989 has been wrongly relied upon, and the same cannot be said to be an admission on the part of the defendant of the present case that he was a tenant under Gurubaksh Singh and
Scott and Dilawar Singh.
Gurubaksh Kaur and Dilawar Singh.
And also this is your building.
He has further submitted that the defendant never pleaded in the written statement that he was a tenant of Gurvat Singh and Dilawar Singh.
And also in the plate.
And no such pleading was there in the plate also. Such discussion and finding
And also
of the learned trial court is beyond the pleadings of the parties.
That's why not admissible also.
And such evidence was not admissible in law, and therefore, on this count, the first substantial question of law is also fit to be answered in favor of the applicant. That's all?
एक atonement मांगा.
No, yes. Now you just tell me what is the finding of both the courts? That you were a tenant of Dilawar Singh? Is this the finding
Yes,
of the
this
court?
is the finding of the
Where is that?
Chairman. Both.
Yes. First, you show me the trial court, that
Sure.
paragraph that you were a tenant under Dilawar Singh.
Yes.
Where is the finding of the learned first appellate court in this
As
case?
18 and 19.
First appellate court.
18 of the paragraph 18.
Para 18.
Last portion.
Yes.
Where you feel simple. Apart from the evidence, it appears from the judgment of the title suit number 125, 1989, page 12, paragraph 22, above discussed evidence made in title suit number 125, 89 clearly shows that the defendant who is examined at P during the 25, 1999 claimed himself the tenant of Gurwas Dilawar Singh. The presence so defendant claimed himself a hostile ownership in the adverse place of my friend. The claimed admitted landlord, para 90, of the landlord of Gurwas Singh, namely Gurwas was tenant number 2 in Dilawar Singh. This portion is also already read by some time ago. Now I'm just jumping at page yes 17, last paragraph 90. Evidence on record that the plaintiff has established his title also issue notice to the defendant about the purchase. It's not the case of the defendant that the earlier landlord is demanded rent from him. It is not necessary to rent to must accept plaintiff as a landlord and then alone he is liable to pay rent. Rather, after establishment of title by a new landlord, the tenant is bound to pay rent to the new landlord. It is also argued that the exhibit 7 name of only one purchaser was mentioned of his entitlement realized the rent from the tenant. ये भी पढ़ चुके हैं, पहले ही पढ़ चुके हैं. हाँ, बस यही पर आके considering all the facts and circumstances on the record, it can be said that there exists the relationship landlord and tenant between the plaintiff and defendant with respect to property. बस वो हमारा एडमिशन था मेरा कि गुरबास पर था उसी के ऊपर बढ़ते यार, इसलिए हम टेनेंट आगे 21 पढ़ते हैं. Once the जो भी है once the relationship is proved और सब कुछ हो गया डिफॉल्ट करना वहीं से सब कुछ बात. That is the core dispute. Same thing by the first appellate court.
Okay, what is on the point of atonement?
First, that if whether has already decided that that was not a count by degree, not a transfer. It was not transfer. Even I will presume to be that is not admission. Even let it be presumed. But I was the tenant under the lovers. There should be a if there was no transfer that by person to the plaintiff, there is no tenancy. Why the question of stepping the shoe of the transfer?
No, but by virtue of that title suit,
Title suit,
by virtue of the title suit, the property,
earlier suit.
yes, earlier suit, the property, the transfer by Vyasu Devi was acknowledged as valid. Correct? So she steps into the shoes of everybody, whosoever were claiming title over the property. Maybe Gurbakh Singh, maybe Vyasu Devi, or whosoever was claiming title over the property. With respect to
But
the
there are
property.
no transfer from the Gurbakh and transfer in our Singh.
You see, a tenant
There is no
is.
admission also. I am not. I
No,
have.
they need not pay any transfer. They need not pay any transfer, but they acknowledge the title of Vyasu Devi.
Who?
Everybody in the suit, because she transferred the property. After all, she transferred the property, and her sale deed was recognized as well.
Their sentence has been recognized. Yes.
So the title of Vyasu Devi, or whatever be the nature of title, it could be adverse possession, it could be whatever be the nature of title, of Vyasu Devi was duly acknowledged by the parties at the stage of compromise.
Understood. Understood.
Right?
Not by me.
Maybe not by you, but she
Under
becomes the owner of the property. If
See,
your
the-
status is that of a tenant, then whosoever becomes the owner, you have to pay.
Why? I haven't admitted anywhere that I am the tenant, and they have also failed to prove that I am a tenant. That's the case. They have failed to state their own case. Pleading. And what the courts have prevailed beyond pleading. And made a very different case that I was in the lover seeing and this. These are the question of fact. That should be pleaded. And I should have been given an opportunity to contribute.
That's all. Yes, what do you have to say to this? Is there any pleading that they were the tenants and the lovers?
What is the pleading? One line pleading that they are the tenants in the suit. That is there. And your lordship, when the suit is filed, whenever.
Vyasu Devi.
Okay, Vyasu Devi. They are the tenants in the suit property, and Vyasu Devi after
I want
transfer.
to see that pleading.
Yes.
Where you have stated that they are the tenant of.
I'll read it out. From para 1 onwards, there how the property ultimately has come to Vyasu Devi, that has been mentioned.
That's
In para 7, with the statement with regard to the title suit 125 of 1979 has been mentioned. That there was a title suit, being title suit number so and so in the court of so and so with respect to the premises in suit, besides others in which Vyasu Devi was also one of the defendants. The said suit was decided in favor of Vyasu Devi, that means she was a defendant. By judgment and decree with so and so, passed by so and so. That again the said judgment, first appeal number so and so was filed before so and so, in which Srimati Vyasu Devi as well as the plaintiff were also parties. The said appeal was disposed of in terms of compromise petition between parties thereto by judgment and decree dated 30/7/1998, according to which the plaintiff is the absolute owner with respect to the properties purchased by him through the registered deed of sale dated 4/4/1990. That the plaintiff is thus the absolute owner with respect to the premises in suit, having acquired the same through the registered deed of sale dated 4th of April 1990, that the defendant is a non-to-one tenant with respect to the premises in suit on a monthly rent of rupees 60,000 only per month payable according to the English calendar month either so and so since before the purchase made by the plaintiff. And then next para that after the purchase of the premises in suit by the plaintiff through registered deed of sale dated so and so, the plaintiff immediately verbally requested the defendant regarding purchase made by the plaintiff and requested the defendant to attorn him as a landlord and to start making payment of the rent to him from April 1990 and onwards. The plaintiff's vendor, namely Srimati Vyaso Devi, also verbally informed the defendant immediately after the sale of the properties to the plaintiff and requested the defendant to attorn the plaintiff as his landlord and to start making payment of the rent to him from April 1990 and onwards. That despite notice he did not pay and all those things have been mentioned.
So it has not been mentioned that under whom he was the
No.
It
It
has
has been
not been
mentioned.
specifically mentioned.
No.
It has been mentioned that he was a tenant over there.
Tenant on this property.
And Vyasudevi became, the vendor became the owner of the property
Owner of-
by virtue of registered sale deed of the year 1990.
Yes, and this is the reason the appellate court has discussed that in earlier suit he has claimed himself to be the tenant, whereas now he is claiming himself to only to dislodge this particular line of his. The stand which he had taken in earlier suit was absolutely different now, which was contradictory to the stand taken by him in the earlier suit. And now the compromise petition may kindly be seen. The compromise which had ultimately been taken place, what are the terms and conditions? My learned friend has read only one portion. Para 2 onwards I am reading.
Just a moment.
Only 2 and 3 are.
Just a moment.
Yes.
Which paragraph I want, please.
Yes. Compromise petition. Para 2, only 2 paragraphs are. A and B. That the entire properties in suit have already been sold by Srimati Vyaso Devi, respondent number 2, to Srimati Sumitra Gupta, Satyanarayana Prakash Gupta, Anand Prakash Gupta, Ved Prakash Gupta and Indu Gupta and Shiv Kumar Gupta through registered deed of sale as well as by Gauri Devi, respondent number 3, to Srimati Duli Devi through registered deeds of sale, and the said purchasers have absolute right, title, interest and possession over the respective properties purchased by them. The said purchaser shall continue to hold and possess the property acquired by them through registered deeds of sale executed by respondent number 2 and 3, and neither the plaintiff nor the appellate nor the heirs of deceased respondent Dilawar Singh, namely Srimati Harbans Kaur and so, the wife widow of late Dilawar Singh and Harjit Singh, the son of late Dilawar Singh, nor his heirs, successors and legal representatives shall have any right, title, interest in any manner in concern with the properties in suit. That in view of the fact that both the respondent number 2, Vyaso Devi, and respondent number 3, Gauri Devi, have already sold the properties, their interests have vested into the purchaser, and the respondent number 2 and 3 have no concern, manner or concern with respect to the properties transferred by respondent number 2 and 3 in regard to the properties in suit. That means Dilawar and all those persons who are claiming, they have no right. So by virtue of this compromise, the right of Vyaso Devi was affirmed and the transfer made by her to the purchasers was also affirmed, and it was mentioned that the Dilawar and all those other persons who are claiming their right over the property, that they had absolutely they or their legal heir. So the effect actually would be that whatever right which any one of them to the parties of the suit was, that stood vested in the purchasers and Vyaso Devi and her purchaser. That would include the tenancy also. If there was any tenant, all the tenancy.
So this is what he wants to say, that when you say that Gyasu Devi, there is nothing mentioned as to who was the tenant, whether Gyasu Devi or he was Dinar Prasad.
Their evidence is there. They say that
Please don't
I
do
was
that.
the tenant of Yasuni. Everyone says.
Yes.
There is
Clear
nothing in the plaint to say as to who was the landlord, whether it was Gyasu Devi or whosoever. And the title or whatever be the right of those Gulbarg Singh and others, that was given up by virtue of the compromise. And thereafter, this the Anand Prakash Gupta became the landlord, and then he had a right to
Realize it.
realize it. So Gyasu Devi had issued notice to them.
We had issued.
Gyasu Devi has not issued any notice to them.
No.
That has not been exhibited.
No. But it was verbally after.
That was your Gyasu Devi has not been examined also before the court.
No, that has also been discussed by the
Right.
lower court that
So
because she had died, she
So
had.
you gave them notice.
Yes. But it has been mentioned by us that Gyasu Devi verbally informed the plaintiff.
So you said, according to you also, whatever evidence was laid, it was Gyasu Devi who was the landlord.
Yes,
with respect
yes,
to the
yes,
school property,
yes.
and they were
Yes.
holding the property as a tenant.
Yes.
So irrespective, according to you, irrespective of the fact as to whosoever was the landlord, once you became the owner of the property and you gave them notice that the money should be remitted to you, they were under legal obligation to pay the
To pay.
same.
Because of the effect of the sale deed coupled with the compromise where
There is
their
also
own
party.
persons, Gurbat Singh and all those were parties, and they acknowledged the transfer, and so he remains a tenant. He
So
remains
what
a
is the evidence apart from the judgment of title suit number of the year 1989? What other evidence is on record to say that they were the tenant owner?
our oral evidence.
That is PW1.
Yes.
It
Oral
was not
evidence
been
and
cross-examined on this point.
and yes, oral
Because that
evidence
has
and
been taken care of by the learned
yes,
counsel. That he has not been cross-examined
on this point. But the appellate court says that he has not been cross-examined on this point.
Yes,
Yeah.
trial court
Yes.
has said so. There is trial court finding that he has not been cross-examined on this point.
That is the error we got also.
PW6. PW6.
PW6. The trial court records that he has not been cross-examined on this point. Correct?
It is running page 68.
Plaintiff in his plate as well as evidence.
PW6 has stated, as PW6 has stated that immediately after purchasing the land, he intimated the defendant to adorn him as a landlord, and also immediately his vendor requested the defendant to adorn the plaintiff as landlord and to pay the rent. Plaintiffs remain intact in his cross-examination, and no question has been put forward to dispute such conduct.
Where is the discussion of this evidence by the learned first appellate? Is there any? There is none. PW6. PW6. Yes, page number 49. Running page 49. Just around the middle.
Yes.
Plaintiff examined as PW6 stated.
Your Lordship is reading
Page 49.
second page, say second para or second line of page 24. Internal.
Page 24, not the second line. I am reading PW6 around 10 to 15.
Yes, yes.
lines.
Yes, Father.
Plaintiff examined us in para
In
17.
para 2, 3 and 6 of cross-examination,
Yes.
he has stated that no partition has taken place between his father and uncle. He further stated that beside distributed property, there is one jewelry shop over plot number so and so owned by them. In para 17, he has further stated that plot was purchased in name of his mother. Plaintiff examined as PW6 stated that the property situated at northern side of the disputed premises belonged to his mother and brother. In para 3 of his cross-examination, he has stated that no partition has taken place with respect to the ancestral properties between his father and uncle. In para 4, stated that the properties are at Kalu Babu Street, a joint property, and Butcher Gully, the property is ancestral and his family was having one shop
This
at
is on
London
something
Tower.
else.
This witness,
This is not on landlord communication.
no,
This discussion is not on landlord communication.
it was his discussion actually starts from this is with regard to discussion on point number 2 and 3. It starts from page 23. But on landlord tenant, the earlier portion. Oral evidences have been discussed in para 15.
Where is the finding?
These evidence have not been
Where is the finding of the appellate court?
appellate court with regard to
Landlord communication.
yes.
I got 20.
It actually starts from para 18.
Para 18, so far as the contention of the appellant.
Yes.
I find.
Yes, I find that the statement given by the defendant in earlier suit that he used to pay rent to Gurbakh store and Dilawar Singh qualifies his statement as admission of his possession, word may kindly be taken, of his possession as a tenant in the suit premise property in view of section 17 of the Evidence Act, and this admission is relevant and may be proved as against the person who makes them in view of section 21 of Evidence Act. And in the civil suit, a party producing a document containing admission by the opponent is sufficient to prove fact in issue if the admission relates to a fact in issue. Here in this case, the judgment where the evidence of the defendant was discussed has been proved and exhibited as Exhibit 3 before the examination of the defendant in this case. In the case of so and so, it was held that where in a suit a party produces a document containing an admission by opponent and the opponent enters in the witness box, it is not obligatory on the party who produces those documents to draw in cross-examination the attention of the opponent to the said admission before he can be permitted to use them for the purpose of contradicting. This court held the that the party produces the document can be permitted under section 21 of the Evidence Act to use them as substantive evidence in case without drawing his cross-examination the attention of the opponent to admission in that document. Learned counsel for the defendant has also contended that strong approach in finding fault in the defendant case has been adopted by the trial court as it is an established law that when the plaintiff has come up with a suit, it is his bounden duty to stand on his own leg. It was contended that the very foundation of the suit of the plaintiff was that the defendant was the tenant of the plaintiff vendor Yaso Devi, and therefore the learned trial court committed error by making a third case taking cue from the statement of the defendant in an earlier suit that he was a tenant under Woodworks Court and the lower Singh, and therefore he was a tenant of the plaintiff. However, I do not find any merit in this contention of the appellant, where one party to the suit claimed that the defendant's possession in the suit property was the result of creation of tenancy, and the party claims relationship of landlord and tenant on the basis of his derivative title and ownership, and on the other hand, the second party defendant claims his possession in open assertion of title and hostile possession. If the evidence is led to establish such relationship, and in particular if the evidence is led to prove the nature of possession of the defendant, and the same has not been considered by the court to give finding on the nature of possession, it does not amount to making a third case. It is established principle of law that in a legal pleading, evidence is not required to be pleaded. Pleading should only contain the material fact upon which the party relies their claim or defense, and not the evidence that he will use to prove this fact. It is the case of the defendant itself that there was a series of litigation between the defendant of descendants of Dattaram Punjabi and alias Dattaram Chaudhary with respect to the respective claim of right title interest upon the suit property. Here I pause. Here I pause. Now, it is absolutely undisputed that all the entire litigation was between the descendants of Dattaram Punjabi according to their own stand. And ultimately, the descendants were all those were parties to the suit, where one of the ultimately to whom the property had come down by way of gift deed and the registered sale deed, she was also a party to the sale. So once the descendants of all the parties, they acknowledge the right of Vyaso Devi, then everything else
That's
falls.
right. The point is that whether Vyaso Devi or Guru Baksh Singh's evidence, whatever has come on the basis of which Guru Baksh Singh has been held to be the landlord, that is not correct, right? Now the point is that whether there is any evidence that the plaintiff, this defendant, was a tenant over.
There are oral evidences are there. There is no documentary evidence, and I cannot show that save and except his own statement made in a separate proceeding. So
That has not been exhibited, so that could not have been taken care of. Now you tell us that what is your oral evidence? Trial court has taken into consideration PW6. Appellate court has not discussed much.
no.
So far as
But it
the
has not
relationship-
disturbed the
Not
finding.
disturbed, so we can see PW6.
Yes,
We have to
because
see
he
PW6.
is the plaintiff.
Because he is the plaintiff and his statement has been relied upon by the lawyer. Suppose standalone that statement is also there. Then also it can be proved that there was a relationship of landlord and tenant if the discussion of the learned trial court is correct so far as this aspect is concerned.
That argument.
PW6 निकालिए. have meter business?
Only one thing, I have. Can I read the entire evidence or not? Then
You can.
मैं इस मुकदमे में वाकई हूँ यह कि विवादित संपत्ति से संलग्न अन्य संपत्ति जिसका म्युनिसिपल सर्वे ब्लॉक संख्या सो है, जिसका म्युनिसिपल होल्डिंग संख्या 930 इज दी सूट प्रॉपर्टी होल्डिंग, तथा रांची नगर निगम वार्ड संख्या 3 है, एवं जो गांधी चौक अपर बाजार रांची कोतवाली जिसमें पूर्व में व्यासो देवी की थी और उनका उक्त संपत्ति पर पूर्ण हक एवं दखल था। यह कि प्रतिवादी तकरारी संपत्ति में व्यासो देवी के माहवारी किराएदार थे, जिसका किराया 60 रुपये प्रति माह। यह कि विवादित संपत्ति एवं उनसे संलग्न अन्य संपत्ति को मैंने व्यासो देवी से निबंधित विक्रय पत्र दिनांक इतना के द्वारा क्रय किया एवं दखल में आए। यही दिनांक 4/4/1990 का मूल रजिस्ट्री के वाला है, जिसे नंदू साहू ने मेरे संचो टंकर के बाद मजबूत विक्रेता को सुना दिया गया और उस पर वो अपना ये की ट्रांसफर का जो बाकी डॉक्यूमेंट एंड दिस डॉक्यूमेंट हैज बीन मार्क्ड। देन यह कि उक्त संपत्ति को क्रय करने पश्चात मैंने नगर निगम से अपना दाखिल खारिज करवाया और दे रहा हूँ। यह कि वादीगण द्वारा खरीदे गए उपरोक्त संपत्ति के बाबत एक मुकदमा नंबर हक बात संख्या 125/1989 अवर न्यायाधीश रांची के न्यायालय में हुआ, जिसमें अवर न्यायाधीश न्यायाधीश द्वारा 29/9/1995 को पारित निर्णय एवं डिक्री के द्वारा हमारे विक्रेता अर्थात व्यासो देवी के पक्ष में फैसला हुआ। यही हक बात संख्या 100 निर्णित डिक्री एवं अभिप्रमाणित प्रतिलिपि है, इसे पूर्व में 3 अंकित किया गया। So here one thing is relevant, that this is mentioning as to the title suit was already there, which was already decided in favor of Vyaso Devi. Subsequently, this was only affirmed in the compromise petition before the High Court. यह कि उक्त वाद संख्या 125/1989 में के विरुद्ध इसमें हुआ, जिसमें व्यासो देवी पक्षकार थी। उक्त अपील में न्यायालय द्वारा इतना को 30/7/1998 को सुलहनामा के आधार पर डिक्री पारित किया गया, जिसके अनुसार श्री भी दिनांक 4/4/1990 को रजिस्ट्री पट्टा द्वारा मेरे द्वारा खरीदी गई संपत्ति पर मेरा पूर्ण मालिकाना हक घोषित किया गया। यह कि उक्त उच्च न्यायालय द्वारा अपील संख्या इतना में पारित सुलहनामा डिक्री की अभी प्रमाणित प्रतिलिपि है, इसे पूर्व में प्रदर्श 5 अंकित किया जा चुका है। मैंने उपरोक्त संपत्ति क्रय करने के तुरंत बाद 1990 में मौखिक रूप से प्रतिवादी को सूचित कर दिया तथा तकरारी जायदाद क्रय कर लिया है। अतः प्रतिवादी हम लोगों को मकान मालिक मानते हुए अप्रैल 1990 से किराया मुझे देना शुरू करें। श्रीमती व्यासो देवी ने भी मुझे उपरोक्त संपत्ति विक्रय करने के तुरंत बाद प्रतिवादी को मौखिक रूप से सूचित कर दिया था कि उन्होंने उक्त संपत्ति को वादी को विक्रय कर दिया है। अतः वादी को मकान मालिक मानते हुए अप्रैल 1990 से किराया प्रतिमाह वादीगण को दें। यह कि मेरे द्वारा विक्रेता श्रीमती व्यासो देवी द्वारा प्रतिवादी को उपरोक्त बातें कहने के बावजूद प्रतिवादी ने अप्रैल 1990 से लेकर आज तक किराया का भुगतान मुझको न तो हाथों हाथ दिया और न ही मनी ऑर्डर से ही दिया। अतः प्रतिवादी किराया का भुगतान करने में चूक के आधार पर तकरारी जमीन जायदाद को खाली कराने का हमारे अपने इतना आवश्यकता है, इस सब को हम स्किप कर रहे हैं।
जो स्किप करना है कर चाहिए।
हाँ, पैरा 15 यह कि मैंने प्रतिवादी को तकरारी जायदाद खाली करने हेतु रजिस्ट्री डाक अंडर सो अधिवक्ता नोटिस भी दिया। इन्होंने तकरारी जायदाद इतना तक खाली करके मुझे सुपुर्द करने को रहा। अतः उक्त नोटिस जो प्रतिवादी द्वारा प्राप्त किया गया, उसके बावजूद प्रतिवादी तकरारी जायदाद खाली नहीं किया, तब हम लोगों ने मुकदमा किया। या कि नोटिस की कंप्यूटराइज प्रति है जिसमें मेरे अभियुक्ता बंटी प्रसाद ने सही पते पर भेजा, पूर्व में प्रदर्शित किया जा चुका है। और यह नोटिस भेजने अंडर सर्टिफिकेट पोस्टिंग का एवं पोस्टल रजिस्ट्रेशन रिसीट है जिसका पूर्व में प्रदर्शित और एक भी अंकित किया जा चुका है। Can I read the entire?
Yes, you just read the relevant portion, not lamba cross examination.
हम लोगों ने भाई दो बहन है, दूसरा भाई सत्य प्रकाश गुप्ता बहने कल्याणी तकरारी जायदाद पर है। मैंने उसे देखा, खरीदा था। तकरारी दुकान प्लॉट नंबर 1461 है। मैंने इन्वेस्ट प्लॉट नंबर है जिसका अगल बगल वाली दुकानें किसकी है, सो मुझे पता नहीं। तकरारी दुकान के बगल का भाई का दुकान है तथा पिताजी का रैयत है। बगल के में जमीन है। मैंने अपना व्यवसाय 89-90 से शुरू किया। 89-90 में मेरी आमदनी कितनी थी मुझे याद नहीं है। मेरी माँ हाउसवाइफ है। छोटा भाई पिताजी को व्यवसाय करने में मदद करता है। यह हुआ सन 1989 में शुरू किया। इलेक्शन टाइटल सूट 25/99 में गवाही दिया हूँ। वह तकरारी संपत्ति मेरी माँ एवं छोटी भाई के नाम पर माँ पिताजी एवं एक ही पर हैं। Then para 5 onwards, तकरारी जमीन में सिर्फ एक दुकान है। तकरारी जायदाद में कोई खाली जगह नहीं है। दुकान का एरिया 8 फीट इंटू इतना फीट होगा। हमने इतना ही जमीन खरीदा है। गुरुबख्श को और दिलावर सिंह का नाम सुना हूँ लेकिन कभी देखा नहीं हूँ। दखल इतना में जिस बात का जिक्र है किया गया उसमें गुरुबख्श कौर और दिलावर सिंह पार्टी थे तथा विक्रेता व्यासो देवी को भी तकरारी जमीन कभी दखल में नहीं देखा। इसलिए खुद के बाबत परिवार के सदस्य को कभी भी तकरारी संपत्ति पर दखल नहीं रहा। जब मैंने वो शब्द संभाला तब प्रतिवादी सुभाष चंद्र उदार को तकरारी संपत्ति पर दखलदार देखा। वे किराए पर भी किराएदार की हैसियत से दखल में है। किराएदारी के संबंधित कोई कागजात नहीं देखा। व्यासो देवी मर गई, उसके पति की मृत्यु हो गई है। उनके वारिस के बारे में नहीं बता सकता। व्यासो देवी के परिवार में किसी सदस्य की गवाही नहीं करा पाऊंगा। प्रतिवादी व्यासो देवी के किराएदार थे। मैंने इनकम टैक्स पे करता हूँ। व्यासो देवी को भुगतान ड्राफ्ट से किया था। उस समय मेरा बैंक अकाउंट था, भुगतान किया गया था। उसका सबूत मैं नहीं दे सकता। ऐसी बात नहीं है कि व्यासो देवी हस्ताक्षर करती थी। Then para 9 प्लेट में para 7 में बात का जो विवरण लिखा गया वह गलत है। अतः कहते हैं कि टाइपिंग मिस्टेक है। उस बात में एक वादी व्यासो देवी भी थी। अन्य वादी के बारे में नहीं बता सकता। मैं उसमें पक्षकार नहीं था। उस बात में प्रतिवादी कौन थे और नहीं बता सकता। अतः उस बात में दिलावर सिंह और गुरुबख्श कौर ने भी वाद संपत्ति पर अपना हक का दावा किया था। उस बाद में व्यासो देवी के पक्ष में डिग्री हुआ। विपक्षीगण द्वारा हाईकोर्ट में अपील किया गया। यह मामला 1990 तक चला। सूट में और अपील पेंडिंग के दौरान खरीद बिक्री की बात हुई, पुनः कहते हैं कि सही है, मुझे इस बात की जानकारी नहीं है कि इस बात में पेंडेंसी के दौरान वाद संपत्ति का अंतरण अवैध है। मैं नहीं कर सकता कि सेठी फरमाते समय अपने अधिवक्ता को बताया था कि नहीं कि तकरारी संपत्ति पर वाद लंबित है। सन 1998 में ही व्यासो देवी के टाइटल में जो भी बादल थे वह छट गए। उससे पहले उनके टाइटल को लेकर विवाद था। तकरारी संपत्ति में दूसरे हिस्सेदार सतपाल और
See, there is no cross examination. ये जो टाइप को लिखा है that there is no cross examination with respect to the fact that you had issued him legal notice, and there is no cross examination with respect to the fact that Vyasudevi had also asked him to pay rent to you. So these two things, and then the court takes into consideration the conduct of Vyasudevi, who treated the defendant as a landlord. I made verbal request. Yes, what do you have to say so far as this is concerned? Is there any
28.
error of finding recorded by the learned
Paragraph
tribunal
28 of
with
the-
respect to?
Paragraph 28 of the resolution of the plaintiff IPW6.
Yes.
ये तक बोलते हैं डिजाइन नहीं किया किया गया
नहीं, ये नहीं बोलते हैं कि डिनाई नहीं की। आपके कंडक्ट को देख रहे हैं, पेज नंबर 68 में।
बोला गया
You just
ये भी
page
बोला गया
number
कि
68.
ये सब हियर से उठने से ये भी बोला गया उसे
Naturally, because Vyasudevi has expired.
नहीं व्यासो देवी कभी क्लाइंट को पैसा देते हुए क्या व्यासो देवी का किराएदार थे या फिर किराएदार थे, ये सब के बारे में भी हेयर से कोड नहीं बना, लेकिन ये खुद नहीं जानते, कभी देखे ही नहीं कभी कुछ करवाया।
ये तो Vyasudevi को नहीं देखे हैं।
व्यासो देवी को देखे
Vyasudevi को देखे हैं, but इस tendency
रेड
को
नोट देखे हैं, पेपर नहीं देखे।
naturally because he comes into picture at much later stage, na?
At
He
9.
comes into picture in the year 1990 only. You just read page 68
60 होती
of the running page 68.
ट्रायल को
Yes, trial court.
टॉप से ही पढ़ रहे हैं। Concern PW2 in paragraph 8 ऊपर से टॉप से पढ़ रहे हैं। Of his glossy evidence stated that he has heard the fact of tenancy from Anand Prakash, who used to tell him entitlement to receive the rent of ₹60 per month. He also admitted that on the basis of information given by Anand Prakash, he gave his evidence regarding the further payment of rent. Similarly, PW3 in paragraph 3 stated that father of the plaintiff disclosed him that the monthly rent of the supervisor is 60. He did not have any personal information of the dispute. PW5 in paragraph 8 also admitted that in his presence no transaction took place between Subhas Poddar and Vyasudevi, nor he has seen any document. PW7 also stated in cross analysis not to see any receipt of tenancy. Certainly, evidence of these witnesses are not directed to the fact of tenancy. Their evidence is support of tenancy are of hearsay nature. All the witnesses examined on behalf of the defendant denied the necessity of an opinion. It is quite decided that the plaintiff has failed to elicit anything substantial to establish the relationship between parties during cross-examination of witness. From the witnesses, witness PW5 in paragraph 7 stated that Vyaso Devi disclosed him about the relationship with Subhas Poddar. Evidence of this witness relevant to show the conduct of Vyaso Devi. PW5 is not a party, who stated that Subhas Poddar as a tenant. Plaintiff in his plaint as well as the evidence at PW6 stated that immediately after purchasing the land, he intimated the defendant to atone this portion as landlord, and also immediately when the Vyaso Devi requested the defendant to atone the plaintiff as landlord and pay the rent, Plaintiff remain intact in cross-examination. No question had been put forward to dispute such conduct. Atonement. ये बात पर जहाँ तक इसकी बात है वो हम लोग किए हैं 28 क्रॉस
They do not say that there is no question put to you so far as cross-examination as to whether Gyasudevi was your landlord or not.
नहीं
They say that the letter was issued and then Gyasudevi had also requested you to
उसके
accord
बारे
the
में
plaintiff.
उसके बारे में लीगल आया था कि अंडरस्टैंड क्वेश्चन इज नॉट presumed to be a substantial evidence. वो कुछ है इसके बारे में भी आया है अभी दिखा P66 अटॉर्नमेंट के बारे में नहीं है उसके बारे में नहीं है और ये साफ साफ चैलेंज किया गया था कि समझ कभी ना उनका किया जाता था ना प्यासों किया जाता था ये बात बार बार चैलेंज की
PW5 has also stated that you were tenant under Gyasudevi.
मस्ट यस सर ही ऑल्सो यस कुछ नहीं उनको बस देखे हैं ना कभी किराया देते देखे ना कोई सब ऑल लेकिन बस ट्रांसपोर्ट दे आर हियर सर दो मिनट there is no such document of evidence introduced by the on behalf of the plaintiff to show the relationship will not be the parties. Either by Gyasudevi, either
See, you are not claiming title over the property. By way of any
It's not
deed.
it's not my claim.
That's not right.
It's not my claim, and it's not a matter of this. The plaintiff has to stand in on plaintiff's claim, whatever he has made the claim in plaintiff, he has to do.
That's right.
And if there is no relationship between the plaintiff and me, that's what he said.
One last submission can I make? Only one submission. Now, Your Lordship, my case is that he was a tenant under Vyasudev, and after purchase I became the landlord and he is my tenant.
You have not stated as to
He-
who was the landlord.
Who was the landlord, but ultimately
In the evidence it has come.
that he is the tenant. His capacity in the property is as a tenant. This is what we have stated. Now, their stand is that no, there is no landlord-tenant relationship. I am in adverse possession. Both the courts have disbelieved his story of adverse possession, giving detailed reason as to why he has not been able to say as to who was the true owner when he came in possession of the property and all those stuff. So the moment he stand of, because he is not claiming the property by way of title also. So the moment his stand fails in the property that he is in adverse possession, and that implies that someone else is the owner of the property, then evidence has to be accepted that he is my tenant. His capacity in the property is accepted. There cannot be a third stand.
And at the end of the day, this is only the BBC Act.
Yes.
Only
And
the
prima facie,
prima
he
facie
would
finding
not
is to
declare
be-
my right. So if there are evidences, because he is not claiming ownership. If there was ownership dispute, matter would have been different. His statement himself mentioned that someone else is the owner.
And during the earlier suit, he also accepted the title which was would go to Vyasapur. He accepted
Yes.
it because he was a party in that proceeding also.
No, he is not a party.
He is not a party.
He has examined himself as a witness
He was a
in
witness.
support of the person
Case on
to
the
whom
blade.
he was saying. So what could be the Yellow Chip? I cannot rely on the finding. I'll be very clear on that. I cannot rely on the finding which ultimately was in challenge in the appellate court and which ended in a compromise. I cannot rely on the finding. But I can always rely on the statement of fact that what has happened in that, which witness has stated what. So that particular statement which he was
So that he was required to be confronted because that particular discussion of the statement, everything, and the court also
I do
actually
understand
did
my
not
difficulty.
believe the
I
statement.
say that, but you may also take into account that I had produced my evidence as a plaintiff earlier in point of time. So he was required to rebut that. The presumption under 114 is only a rebuttable presumption. He was required to have brought the original exhibit or his own examination, and he ought to have shown that no, the recording which the trial court has done, this recording is actually not in accordance.
The trial court has not believed
He's not.
His argument is twofold.
Yes.
Firstly, that document was not brought on record, that piece of evidence was not brought on record. And secondly, he says that it has been selectively taken because the court has disbelieved his statement.
No, what statement has been believed? That he is the tenant of a particular person. That has been believed. Not that he is not a tenant. His claim that he is in the
No,
capacity.
this evidence in the earlier suit has not been believed by the court.
No, it has not been.
It has not been believed.
No.
So the court itself does not believe his statement. And then you are relying upon his statement.
Court does not believe only but his statement that he is in the capacity of a tenant, that he himself is admitting. And now in the instant suit, he is claiming to be in adverse possession. So I am just trying to show that with regard to his own statement, that he was never claiming ownership of the property. He was either a tenant or he is now claiming himself to be the adverse possession, which he has failed to prove. He has not mentioned anything with regard to his adverse possession. And repeatedly.
So according to you, the onus was on him to prove his evidence, to bring on record his evidence to
because there was no documentary evidence to show that he was my tenant. I led evidences, oral evidences, and then he was required to have shown.
That he never took a stand
No.
that he was the tenant of it.
Yes. Now, because he did not lead any evidence, or he does not even disprove the whatever had transpired earlier suit. He never led evidence. I had already produced that document.
This particular recording in the trial court's judgment, has he been confronted during the course of trial in this case? And who has confronted him with this statement?
With this statement,
Yes.
it appears that. I'm not sure. No, probably it has not.
He didn't do 8 in the
But what would be the effect? I said that I'm repeating that line. I lead evidence earlier in point of time. He does not bring anything to contradict that.
There was no such pleading itself. There is no evidence.
Pleading was that he was the tenant.
And I challenge.
a negative.
So irrespective of the fact whether he was a tenant under Dilawar Singh and Gurvat Singh, once the property is transferred in your name, he was supposed to make payment of rent.
Yes, that is the ultimate.
Irrespective of the
Yes,
fact whether
yes,
he was
yes,
a tenant
yes.
under Gurvat Singh
Yes.
or
This
he
is
was a
what.
tenant under.
Yes, for reason that after the sale deed there is a compromise. So compromise has to be read along with the effect of the sale deed. The joint effect of the two has to be seen. So whatever right the Dilawar Singh and Gurbakh Singh had, that stood admitted they, because they relinquished their right on the property. So entire right vested in the purchaser. And with regard to pleading, Your Lordship,
And this finding of landlord-tenant relationship would be at best just a prima facie.
yes, only for
Nothing more.
ambassador. I would not get title on the property. On the basis of this, it is a list between two of us where only limited question of title has to be seen when there is no apparent or written proof of landlord-tenant relationship. When I have led evidences and I have shown that, if he would have shown that no, he is not my landlord, someone else is the landlord who was not a party to any of the proceeding, and he was not even a party to the compromise, then the matter would have been different. If he was not his landlord, he would have said that no, Dilawar Singh is my landlord, and he was not a party in the earlier proceeding. Then the matter would have been different. Here, whatever he says, that is whatever landlord which he claimed, he was a party. He says that no, I recognize the right of the Vyasura. And what is pleading that is required? Your Lordship, recent judgment of my submission would be there was sufficient pleading with regard to tenancy. I said that I am the landlord after the transfer of the property to me. He is the tenant on the same property. This was sufficient. Now he cannot say, no, there was not sufficient pleading. Because the parties were aware that the essential issue was whether he was a tenant on the property or not. Only one judgment, if Your Lordship would note that final, I could not get a printout. This is the recent 2024 on pleading. On pleading, what is required? 2024, volume 18. There. Para 26. It would be better that from para 25. From the perusal of it, it is more than clear that plea of honest factum was pleaded in clear terms. Whether or not the plaintiff were able to prove it would be a different question of fact. That it was pleaded is more than apparent. The High Court was thus not right in holding that, recording the finding that the plaintiff did not plead with respect to non-est factum. It would be appropriate at this stage itself to refer to the settled legal position in this aspect. In so very aptly put, the question for the court to consider in such matters is whether the parties knew that the matter in question was involved and whether they led evidences about it. We profitably quote para 10 of this adjournment. But in considering the application of this doctrine of the facts of the present case, it is necessary to bear in mind the other principle that considerations of form cannot override the legitimate considerations of substance. If a plea is not specifically made, yet it is covered by an issue by implication, the parties knew that the said plea was involved in the trial, then the mere fact that the plea was not expressly taken in the pleading would not necessarily disentitle a party from relying upon it if it is satisfactorily proved by evidence. The general rule, no doubt, is that the relief should be founded on pleading made by the parties, but where the substantial matters relate to the title of both parties or the suit are touched, though indirectly or even obscurely in the issues, the evidence has been laid about them, then the argument that a particular matter was not expressly taken in pleading would be a purely formal and technical and cannot succeed in every case. What the court has to consider in dealing with such objection is, did the parties knew about the matter in question was involved in the trial and they led evidence about it. If it appears that the party did not know about the matter in issue and the trial, and one of them had no opportunity to lead evidence in respect of it, that undoubtedly would be a different matter. To allow one party to rely upon a matter in respect of which the other party did not lead evidence and had no opportunity to lead evidence would introduce considerations of prejudice and doing so and so. In Bachaj Nahar versus Dilima Mandal, it has been. So basically here also our pleading was that he is the tenant and the defendant was aware that we were claiming on the basis of it. This is my submission. And therefore now they cannot say that we have not pleaded. This is all. One last line. Your Lordship, there are no equities in favor of a person who is claiming adverse possession. Here the Rent Control Act at least gives a shelter to the tenant. Now once that Rent Control Act goes, he has absolutely nothing. That shelter is also not there. And here, as your Lordship observed, that it would only be a prima facie for discussion of whether there was under the BBC Act this was maintained. My title has to be seen only with respect to
Both the courts below represented that there is no evidence whatsoever of tenancy and under bias will be all with me. Only on my alleged admission judgment has been passed. A different thing. And I am also citing you. 145 and the delivery not taking you.
What is this?
Only you
Rajendra.
Vinay Kumar Singh was on the matter of 145 evidence and then इसको जो ट्राइबल के बारे में annotated intelligence this important for this supporting and it is for the plaintiff to prove not my own.
Which paragraph are you relying upon? These reference. Vinay Rajendra Tiwari para number.
Vinay
Vinay Tiwari para number.
para 12 and 13.
Twelve and 13.
Bag it.
In order to if there is a landlord, right, and the property is purchased by somebody, in order to acknowledge that the purchaser is the new landlord, at least that intimation is absolutely necessary. Without that intimation, he does not acquire the status of landlord. In the present case, that letter has been served.
Letter has been sent by registered post also. And that has been marked as Exhibit 1B. And he does not dispute that. He only says that I am not the landlord. He only disputes the right of Vyaso as well as mine. That is what he is contending.
So should have instituted this.
Therefore, should I institute this one?
And then Vyas should have issued notice to you that I have sold the property, now you are the tenant of my purchase.
That statement that Vyaso also asked you to make payment of rent is also intact.
No, I have challenged.
No,
I have challenged
so far
the-
as the findings of the court.
How finding of the court, but I have challenged. The requisition itself was an answer.
What they have said that because she is not the landlord.
She might be the landlord, and you are also the owner, but you are not the landlord. And second one is regarding the page paragraph 7. And that short synopsis also have so there is
It can't be like this. You see, there are so many things you have put in which you have not even argued. And yes, synopsis as a naming. I do not like the synopsis.
That might be considered, but I have not submitted.
No, not submitted. Many things you have said that this was, you just. I am just keeping it, but my judgment will not be based on your synopsis.
Only on the person of law, whatever I addressed.
Whatever you say in your written submissions will not be
But
taken.
it is also there in the synopsis. What I have
That
submitted.
your synopsis is nothing. I have heard you for the whole day. Right? Things you have not argued, I will not record it. Simple.
No, whatever I have argued is there in the
That's
synopsis.
Whatever you have argued, that will be only. The points that you have not argued is not going to be subject matter of my discussion. That's all.
Yes. On judgment on adornment, this is para 32 of this Mekan. You've seen I have highlighted it.
Sir, 109 is enough.
So what do you want to suggest by this?
By this,
It is
the
also not required.
yes, on adornment. Now, when the moment the property is to transferred from the earlier Vyasur to me by a registered deed, and that is confirmed in a compromise in which all the descendants of the parties were there, then naturally I become the landlord for the property.
And no atonement.
And
And at least
his acknowledgement is not required for that I am now you are the landlord. Even if he
But first he has
disbelieves,
to prove
then what?
my tenancy. Then only. It might be.
suppose a person is a tenant under the third party,
Yes.
and then you acquire the title from the fourth
Third party, yes,
You acquire the title from the fourth party.
yes.
Can you dispute it?
No. But here is a case where that third party is also signing in a compromise. So collective effect of the sale deed has to be read with the compromise decree. That
And he
cannot
has
be
not
read in
disclosed-
isolation.
And he has not disclosed under whom he is the tenant.
That he does not do it, and he is claiming adverse possession. Who is the true owner? He could have said that third, fourth party is the actual owner of the property. I am claiming
That's
adverse
not my
possession.
case.
His entire defense has failed. Defense of adverse possession has failed.
We conclude here, the judgment is sealed. Some of the, one of the substantial question of law I have rejected, you will get it in the final judgment. It will just be that arguments are completed, that will be there in the order. And since no further dictation has been given in open court, we will give the judgment short. We will not keep it pending. When the details, arguments are recorded, then I can take my own time. But this judgment you will have very short.
In the meantime, till it comes, I will not execute. That I assure.
That undertaking.
Even otherwise, your lordship have stayed.
That undertaking may be.
Yes, yes, I'll. My undertaking, your lordship may record.
Quite a complicated matter.
No, I mean, it must not be disposed of or written and having matter. I am not executing. Your lordship may record my.
That is sufficient. The statement is more than sufficient. There is one matter where an adjournment request has come, posted on next Monday.
Yes.
An adjournment request has been circulated, serial number 1, on the ground of illness of Mr. Rajiv Kumar. Sorry? Rajiv Kumar, advocate. Post on next Monday.
I'm seeking my Lord's permission to mention one matter. Your Lordship, it is listed as serial number 5 today. In case if it is not taken up today, I'm
Will not be
requesting.
taken up.
If it can be for tomorrow, I'm just requesting if it can be tomorrow.
We have so many things to do. These appeals take quite some time.
I'm just requesting if it can be taken tomorrow, subject to my
There
Lord's
is no
convenience.
urgency as such. You can wait or you can try it in the next week. Normally, if anything urgent is there, the mentioning is at 10:30, not at that 1.